We can get started while Harriet takes off her coat. We have a quorum now, so we have here at the meeting Harriet Applegate, Roland Anglin, Jonathan Ciesla, Guy Thelian, and myself, and Graham is gonna be here in a little bit. And we have Craig Kluge on Zoom. We also have on Zoom our facilitator, Kevin Butler, and of course, Lee Kremrine from the Law Department is here with us as well. So good to see you all. Our first order of business is to approve minutes from March 20, March 27, and April 3rd. Do I have a motion for that?
So moved.
Any second?
Second.
Any discussion? All in favor?
Aye.
Any opposed? Okay, thank you. For purposes of our agenda, I thought, for one thing, that we might want to plan to take a break, maybe around noon for 10 or 15 minutes, just to let people stretch their legs and just take a breath for a minute. And secondly, I was thinking we should take advantage of Kevin being available to cover the non-discrimination provision first, and then go to the chart that Lee prepared of the various issues that the facilitator in the law department provided some guidance on. Is that okay with everybody?
Yes.
Okay. So with that, we can go right into the non-discrimination provision. So, Drew, since this is your draft, is there anything you'd like to say as an intro before Kevin offers his comments?
Yeah, a couple of things. We're paying attention to national agencies that are trying to strengthen their protections for their employees, anticipating a possible authoritarian takeover after November. The Ohio legislature is a good example of that authoritarian takeover, trying to strip people of their bodily autonomy, women, trans people, that kind of thing. It seems to me it would make sense for Cleveland Heights to do everything in its power to solidify protections for minorities, kind of thing. That's one of the reasons why putting it into the charter means it is more durable than an ordinance, because an ordinance can be swept away when one council seat changes and the vote changes, kind of thing. So those are the reasons I think it makes sense to have the city embed these in the charter, protection against a possible rise of authoritarianism and more durable kind of thing. As far as the language goes, a lot of us who have worked in social justice, marriage equality, that sort of thing, realize that if your group is not specified as having protection in a law, when push comes to shove, you probably will not have that protection. We really found, whether it's talking about marriages between a man or woman, et cetera, that kind of stuff. Sorry, Gabe, am I speaking too long?
You have no reason to interrupt your discussion or your speaking.
If your group is not specified as having protection, you probably don't have that protection. So even though it's a rather long list, I feel that it's important to be as inclusive as possible. No list can be fully inclusive kind of thing, but we can do the best we know how to at the beginning and make it better as time comes on. So again, I feel putting this into the charter is important because it's more durable that way. And even though it may seem like a laundry list, any group in this thing deserves our full consideration as protection kind of stuff. So those are my current statements about this.
I have a question. Given that one of the problems with listing is that there's always going to be somebody left out. So to address that problem, could you say, or any other minority or marginalized entity?
Let's see. Any other
Because you want to allow for inclusiveness, future inclusiveness.
Or any other classification protected by applicable federal, state, or local law. Hopefully that would cover it,
Any other
Well, see, so what's the point of listing people if we're just gonna have a catchphrase for applicable? Like, I'm nervous about just listing people.
Yes, I'm not, because as I said, well, let's, for example, you want to not protect from discrimination? Pick a group.
That works for ordinances, not necessarily charters. So that's my concern. I mean, charter seems like it's more intent. And then I talked to it was two organizers at Equality Ohio. And yes, when you do ordinances, you want to list every single group. However, with charters, that's unclear. And so that's why it's like, okay, so based on yours, let's pick relationship status. They're not in there.
Right.
So do we add them? Do we try to think of everything? Like that's my concern about listing is we're always gonna leave somebody out. And could we do something a little more statement-wise about not discriminating or that the ordinances or laws should be interpreted in a non-discriminatory fashion, like something like that. That's where my thoughts are currently.
It does mention partnership status.
Point taken.
So, Harriet, if you want to add more language to say.
No, I think that probably covers it. I just wanted to make reference to, you know, marginalized or minority entities. Other that might not be on the list.
Yeah, and again, it's, no list can be exhaustive kind of thing, but I
Right.
feel it is, having been in a situation where a text does not mention my group and knowing the repercussions from that, I feel like it's incumbent on us to be as progressive as possible, to be truly an all or welcome city. To list as many people as we know about, and then, you know, if things change, we can change as well, but that's why maybe it seems a little bit cumbersome to people, but it seems worth doing.
Does anybody else have any comments before we let Kevin speak for a minute?
I have one quick comment. I mean, initially I wasn't inclined to support this, but I do think, you know, it's kind of, there's some advantage to sort of setting putting Cleveland Heights on record, especially in view of, you know, coming authoritarianism, whether the elections are won or lost, we still have coming authoritarianism, a huge movement toward authoritarianism, and it is true at the state level as well as the federal. So I don't like the note. I didn't, you know, the notion of the nuclear free trade zone or whatever. That's laughable, and I think it was probably laughable then, but this is not quite in that category. I don't want Cleveland Heights to be seen as laughable, like that made us seem. But this seems to be much more, you know, it really has more gravitas. And I think it's more central to, you know, to what we're about. And so at the risk of getting on our high horse, I mean, it does seem like it might, I don't want us to get on our high horse, but it does seem to be a nice statement for us to be making.
Thank you.
I did have one thing for when Kevin speaks. Kevin, do you have the language as proposed by Drew?
Yes.
Okay. I just want to, because it differs slightly from some of the pieces you would put forth. So I just was wondering if there was any conflicts or issues with that. And I didn't know what you were going to cover, so that's just one point I'm curious about.
I'm glad to address whenever you'd like me to.
Cool.
Okay, Kevin, you want to proceed?
Sure. Well, thanks for the opportunity to be with you. And Linda, just so you know, I've got additional time today, so I'm glad to stay on for as long as you need me.
Okay, thank you.
With respect to this particular issue, I know I sent a real lengthy email, I think it was last week or and that was when you were last meeting. I'm not sure if you even got to that topic that particular day, but I think you did. What I'm hearing is that there are questions that revolve around under enforcement, which is to say you would be worried about leaving out protected classifications in a document that's not easily amendable, which is the charter. And over enforcement is something that I think I probably touched on in my lengthy email to all of you previously. When I say over enforcement, I mean that I'm coming at this from the perspective of someone who has the job as a law director of ensuring that my government follows the provisions of a charter. And I think it's more easily done when protected classifications are cognizable, they have delineation around them, they're easily definable, because then you know what to enforce, what to protect against. And when the wrongdoing is identified clearly as well, then it's easier to enforce that particular provision. There were a couple of issues that I think with the draft that I reviewed then, and which is I think the current draft, but I'll just bring to your attention. And these have to do with, again, a law director's ability to enforce the charter in order to ensure that the charter is being followed by the government. The protected classifications as they stand now in Drew's latest draft are, to me, easily definable. And so I don't think that's an issue. But if you were to consider maybe adding those additional classifications like traditionally marginalized people or something like that, that to me is much harder to enforce, because as a law director, I'm not sure what that means. I know what military and veteran status means, what source of income means, what citizenship status means, etc. But I don't know necessarily what like a traditionally marginalized classification would be. And that would be much harder for me to tell the government it's not doing well if it acts in a certain way and someone accuses it of discriminating against a traditionally marginalized class. In the documents that you previously have received from me, which is a compilation of charter provisions that touch on non-discrimination, and one thing was also very clear, and that is those provisions generally almost always relate to either discrimination in employment or appointment, and discrimination in the provision of city services to citizens. And so if you were to look through that I think it was an 8-page compilation, you would see that by far and away most of the municipalities that added enforceable charter language to their charters around non-discrimination touched on in those two areas, discrimination in those two areas, and those two areas only. Drew's latest draft also touches on those two areas, but the additional language found in that draft, which is sort of in the middle of the text, or any other, or discriminate or have the effect of discrimination. Those carry this provision, those words carry this provision outside the realm of just city services and employment. And to me, as someone who thinks like a person who's got to enforce the charter, I struggle to imagine how I might enforce that additional language vis-a-vis my city government. it's just less, I think, the milieu is less defined. When my government is charged with not discriminating or having the effect of discriminating on the basis of blank. Because my government does more than just hire people, promote people, and give citizens access to city services. My government also legislates. And I would want to be sure that if I'm charged with enforcing this, I would know how to do so in everything that my government does. So there have been suggestions floated among you that if you want to make the statement, to the public that you are a progressive city when it comes to non-discrimination, you could make that statement in a way that leaves the legislating in this area to your council, and have them set the policy. You could also put the policy, as this suggests, in the charter. But if that's the case, I would only caution you against creating a policy where the enforcers of that policy would have a very difficult job enforcing it.
Can I ask a question of Kevin?
Sure.
Kevin, this is Harriet Wood. So if you were asking your advice on this, are you suggesting that we could eliminate or have the effect of discrimination on, or are you speaking to the whole paragraph here? I mean, could we modify this to actually persuade any enforcers that they could enforce such a provision, or are you talking about the whole thing?
Yeah, so I appreciate the question because I think it clarifies what I'm saying. I think if you eliminated the text or discriminate or have the effect of discrimination, the effect of discrimination, if you eliminate those 8 words or so, then what you've created is a policy that is enforceable. It says that the city government shall not discriminate in providing access to city services and shall not discriminate in its employment and promotion decisions on these bases. That's enforceable to me. It's much more easily enforceable. Because then I don't have to worry necessarily about city council passing, I was using these as kind of examples, an ordinance that prohibits minors from doing certain things in the city for public safety reasons. And I mean, that additional language that Drew has added is helpful because then I could make the argument that the public safety and welfare and personal safety are the rationale behind that kind of legislation. It just makes it less clear, as I imagine it, as to what it is the charter provision is attempting to do when you expand it to include all actions of the government. It just becomes a little more difficult to enforce. That's all.
Yeah, so I suggested the language to add to the preamble because I thought that might be another way to emphasize at the beginning of the charter when we're laying out basically our mission statement that these things are very important to the people of Cleveland Heights.
I'd like to speak to that. Kevin, one of the reasons I prefer having that language in is the city council, as you know, does more than legislate. Currently, the committee of the whole has been meeting, granting funds to various organizations and groups, so dispersing funds. I'm not sure if they are art funds or whatever kind of thing. Another city I was involved in did similarly. We made grants to local service organizations and whatnot. Those grants, and there was also a few years ago a controversy. The city, I believe, was awarding a housing sort of contract to a religious group that had a possible history of homophobia, and there was some concern about that. I was also in a city that was making grants. A local gospel mission applied for a grant, but some of us knew that they discriminated against LGBTQ people and women who stayed at the shelter. It was a shelter. Women there were not allowed to go to community college classes. So we used a similar provision about not having the effect of discrimination to say we cannot fund an organization that it in turn discriminates. So I don't know if you're following that argument. So it's like moving beyond just the legislation affected actions of the council to community, grants, awards, that sort of thing to cover them as well.
Yeah, I follow the argument, and it's a fair argument. So I'm trying to imagine myself in a situation where the organization that was slated to be funded, the religious organization that was slated to be funded for housing dollars, comes back to the city after the city makes a determination that it would violate its charter if it sent money to that organization. That organization would then be able to employ the very same charter provision and say that you're discriminating against us based on our religion. So, and this is not unusual for, I mean, we've seen this in affirmative action arguments recently for multiple protected classes to be on either side of a discrimination argument. It's tricky though if you're looking to your government and saying you need to uphold the charter. Both parties, by the way, are looking at your government and saying the same thing.
Yeah.
The party that is aggrieved by the perception that the religious organization discriminates, and the religious organization itself, which then can make the argument that the government is discriminated against it.
I have a question. One of the things I noticed here is that, one of the things I recognize is that the city of Cleveland Heights has a certain employment, let's just speak in terms of dollars as impact, has certain employees. The city of Cleveland Heights also has probably a budget for purchases from vendors and suppliers, which far exceeds their employment by 5 or 10 times, whatever it would be. And we're not doing anything here to say that the city is supposed to be aware of, and I recognize the difficulty of enforcement, Kevin, but the idea is that our impact in the city and our impact in terms of discrimination, if we don't care about the people we buy services from and they're off discriminating, I mean, that has a huge impact and we're funding it.
Yeah.
So is there a way to accommodate specifically the need for enforceability, Kevin, and at the same time include references to in awarding contracts to vendors and contractors and awarding grants and all? Is there a way to do that which makes it specific enough to make it enforceable, and at the same time bring enough of the city's impact into discussion or how this particular provision would impact the city, to benefit the city, benefit us, and benefit in not having a discriminatory environment?
It's an interesting question.
I'll answer the question because is there a way to? My feeling is there's always a way to legislate well, whether you put it in your charter or your ordinances. And in my view, you have to make the decision that either you are going to make the general statement that you do not, that your city government is going to act in a non-discriminatory way. And you can list the protected classes if you like. Or you have to get prescriptive in your language so that the government knows exactly how it's supposed to behave. And so if in the contracting matter, and I think we've heard from Lee already that the city's got some anti-discrimination provisions in its purchasing and contracting ordinances. If you want to bring some language into the charter that forbids the city from discriminating by supporting contractors that discriminate, then do it. Then make it prescriptive. Make it fine enough so that the government knows in the future what it's not supposed to be doing. My only concern, my overarching concern with the language as it is right now is that extra language or discrimination, the effect of discrimination. It applies to everything and anything, which means a lot of people can make an argument, potentially, that the government is discriminating, but that's of course not its intention.
So I have a question, Lee, in the city's ordinance that prohibits discrimination in city contracts, what's the thrust of that? That they ask their vendors to confirm that they're not discriminating in their own employment practices, or what exactly does it do?
I believe so, but I don't know the details exactly, but I think that's right.
Okay,
I have a follow-up question. Are you done with that question?
Yeah.
I have a follow-up question to that. So, I'm an environmentalist and I've recently read, not so recently that I remember the details, but you know, there's even a movement to give agency to things like trees. And so I guess there are also movements like, how do we stop palm oil spreading, you know? So the palm oil thing provides a good example. Can this, I'm assuming this would be done by ordinance and not in the charter, so it's not immediately relevant, but I'm just wondering in that, the ordinance that Linda referred to, is there some way if the city decided it didn't wanna buy products that included palm oil, would that be covered by that ordinance, or would that have to be a separate kind of thing? It's a supply chain, I guess,
it would be a separate thing.
it'd be separate.
I'd have to read it, but I think that.
I would be pretty confident the city doesn't have an ordinance that relates to palm oil.
Yeah, well, I mean,
But tell me if I'm wrong, but
I mean,
I think if you
things like
search
that.
the Ohio Revised Code and find city ordinances, there probably isn't one that relates to palm oil.
Well, there might be ordinance that relate to supply chains that, you know, it could be added to a list of other categories. I mean, I'm sure you're right about something specific to that, but I'm just wondering because there's all kinds of goods that can contain, you know, cancer-causing agents, toxins, and all that stuff. And I just wondered, does the city have anything like that at all? Benzene in things, or you know, whatever might not be. You know, they keep throwing out protections at the national level. So I'm just wondering if we have anything like that. And not to mention, I don't expect that any of that stuff would belong in a charter, but it's something to think about proactively going into the future.
Yeah, I can't think of anything. I could look for you, but
Well, I think the city is forming commissions around, you know, sustainability, environmental impact, that sort of thing. So as they get up and running,
Right.
they may be looking at those issues.
Yeah.
I have a question for Kevin. The last sentence, Drew added or inaction based on systemic inequalities. One, is that less, does that last sentence, do those additions raise any concern?
Yes, and I think that that's a separate issue, and it's certainly something we would want to discuss, and I think it's been raised prior to now.
Okay, the only reason I asked is
Prior to this
because,
meeting, which is, do you want to have a separate, I mean, I wrote that I started by offering a suggestion of what discrimination might mean. And I appreciate that Drew, you suggested, tweaking that and using it. But that is a good example of some additional language that I think might prove difficult, systemic inequities. Because then you need a law director to be able to tell you that your action is based on systemic inequities. Because it's a more shifting standard.
see, and the reason I asked is because, we're talking about the or have the effect of discrimination. If the value was like systemic or something, then someone who wasn't like, for instance, I'm white, and if I said, well, you're discriminating against me based on race, I feel, I'm not a lawyer, that you could say, well, that's not a systemic inequality. I'm wondering if it feeds back into it. That's where it's rolling around in my head. So what you just mentioned is interesting about defining systemic. I mean, not you, but like a law director would have to.
Someone in some government in the future, right?
Yeah.
Or some aggrieved party who's looking at that and saying, well, was the decision based on systemic inequities? It's just a more difficult thing to prove, I think, or disprove maybe. It's not offensive language to me. It's just a little more difficult. Again, from an enforceability standpoint, it's a little more difficult.
I thought.
And what I meant was, what I meant about defining discrimination also being a separate topic for discussion is that the city in Chapter 749 of its codified ordinances defines discrimination in with a separate definition. And so should those be the same? That's another topic for discussion. I don't have a real strong opinion on that. I think that they could stand apart, the two definitions, but it's worth a conversation.
And Kevin, I'm sure you understand that I put that language in because we know that structural injustice does not rely on personal animus to keep operating. Once it's structural, it sustains itself. And so I thought, that we had to make sure we're not just looking at personal animus as the source of, some types of discrimination.
Yeah, I think that's fair, Drew. And also, so if that's right, it actually takes away any sort of feeling of ill will from the analysis. And that kind of systemic inequities language probably would apply more to having the effect of discrimination, if you were to keep that language in. It's what a lot of lawyers would say, discrimination on its face versus discrimination as applied, and having the effect of discrimination as discrimination as applied, systemic.
Yeah, so one question I have is if the city has a definition of discrimination, which I think is stated in your email, Lee?
Yes, for purposes of the ordinances that exist right now.
Yeah, so
Do you mind if we read that really quick?
Yeah, can we find
Out loud?
that?
it defines discrimination as any act, policy, or practice that, regardless of intent, has or had the effect of subjecting any individual to different treatment as a result of, and then there's a list of categories. And then there's an exception as to age, concerning housing practices and or education practices. So my question is whether it's better for the charter and the ordinances to use the same definition of discrimination does it cause problems if the charter has a different definition than the ordinances do? And I recognize ordinances can always be adjusted accordingly, but it just kind of bothers me that there would be two different definitions.
Do we have a printout of that email from Leanne?
No, I don't
No.
think so.
I think we might have had it last time. When did you send that?
No, he sent it in between meetings.
Okay, I printed it. Would you like to see it?
Well, yeah, because I, without the language in front of me, maybe it's not compare.
Well, the list can't, the list isn't gonna be the same list, I'm sure.
Well, no, it's not the list I'm focusing on at this moment, it's the definition of discrimination. Because the language in the city ordinance is regardless of intent. And the language we have in the example that Kevin drafted and then Drew edited does refer to animus, which is intent. So they're quite different.
Well, so again, it says defining discrimination as any act, policy act, that's pretty broad. Policy or practice that regardless of intent has or had the effect of subjecting any individual, and I would add, or group, to different treatment as a result of, and then it does the age, race, et cetera, kind of thing. The one, and I did use this in creating the list, the one thing I took out is the non-consensual dissemination of that individual's private sexual images, because I thought, I didn't know if we wanted to go that far, because that's the new kind of sexting, that sort of stuff. But so saying discrimination is any act, policy, or practice that regardless of intent has or had the effect of subjecting any individual to different treatment as a result of, and then the list. I would, just say any individual or group to make sure that that covers that sort of a thing.
So you're reading from the city,
This is
the
what
current
the
ordinance.
currently
Yeah.
definition, yes.
And that is in what context, Lee?
The ordinances only would apply in the fair practices, the fair practices ordinance, the discrimination and contracting.
So that's just for contracts?
Contracting is fair practices, which is housing, public accommodation,
Okay.
and educational institutions.
But using it in this context would apply to acts of the city council and the mayor as well. It would take it to the, more global level of the city itself. So again, it's, that's a perfectly acceptable one, but that does say any act. So we're basically covering any actions that the city council may take. And it does say regardless of intent, so to Kevin's point, you don't need the personal animus to make it discrimination. I'm sorry, there aren't more copies of this.
So the suggestion is what?
Linda's suggesting, I believe that in that last sentence where we define discrimination, because Kevin suggested it would be good to use the current city's definition of discrimination.
Oh, I see, just to use that definition.
Instead, yeah.
Well, I'm just asking whether if we use a different definition in the charter, how does that impact ordinances that are in effect? Does it mean that you end up with both definitions applying essentially, or does the charter one take precedence over the ordinance one?
Yeah.
I just don't know the answer to that.
Yeah, good question.
If you're taking Kevin's suggestion that discriminator had an effect of discrimination, if you're eliminating that, then you don't have no need for a definition of discrimination.
Lee, can you explain that?
Well, discrimination doesn't, if you eliminate that language, then discrimination.
Which language now?
Discriminator have the effect of discrimination.
Okay.
The last sentence.
No, in the first.
Oh, in the
sentence,
beginning.
In the first sentence.
Oh, which we were contemplating
Oh, okay,
eliminating.
thank you.
And it doesn't appear anywhere else in this provision.
Oh,
so
I
it
see.
needs to be defined.
You don't have to define it because.
So in other words, if we delete that phrase, we would also delete the last line, the last sentence.
Yes.
And if I get it right, kind of to Linda's point, if the city changes then the definition of discrimination, which this is done by ordinance, then it trickles back up to the charter.
Oh, does anything?
Because if it's by ordinance, the city can change it whenever they want.
Well, I wouldn't say it trickles back up to the charter, but I would say that the city has the flexibility
Yeah.
to adjust the ordinance, to add additional categories as things develop,
Mhm.
as our understandings evolve. And
So would the charter refer to a section of the codified ordinances
No.
for
We wouldn't need to.
definition?
I don't think,
Or would just bring forward into the charter what has been defined in the ordinances?
well, the point is, if you look at this language, we only added a definition of discrimination because we use the word up here. If you
Right.
take this phrase out that's
Oh,
in
it's
brackets,
okay.
you don't need the definition.
Okay.
I may have missed this. Lee, did you answer the question about city contracts 171.011?
Not exactly, just generally, but I think it is short.
Okay. Sorry, you may have cut out. All I'll just say is that, yeah, 171.011 is that ordinance that says that no person who is contracting with the city shall violate chapter 749, which is the broader anti-discrimination chapter.
Okay, that's helpful.
That's all.
So those are already in place and they're not considered problematic at this point, is that correct?
Are you asking the ordinance about the ordinances?
Yes.
Sorry, what was it?
I wouldn't really be able to speak to whether or not the city finds them problematic. Sorry about that. Maybe that's a better question for Lee.
What we're just talking about, it's like what the city has in place already about contracting and not contracting with people who can discriminate. Those are working?
I'm not aware that there's a problem with
Okay.
them, but.
Okay. I'm just saying because, you know, what we're hearing is we want to make sure there aren't problems with enforcement. And currently whatever the situation, nobody's experiencing problems with enforcement of those.
I'm not aware of it.
Okay, all right.
So where are we? I know we're asking
Well,
like,
let me-
we're asking like, but I just, kind of curious where we are.
Let me suggest this, do we want to entertain a motion to revise the draft to take out the words or discriminate or have the effect of discrimination and take out the final sentence? Just to take a vote on that?
Seems like that's the direction we're going in.
I'll make that motion.
Second,
Okay, could you please repeat the,
The motion is to, in the draft language that Drew presented, delete the words or discriminate or have the effect of discrimination and delete the final sentence. That's my motion and Harriet seconded it. Any discussion?
I need a second to read it, but
Sure, take a minute.
Just a quick question, is that final sentence the one that's defining discrimination?
Yes,
yes.
Who's speaking?
Sounds like
Graham.
Graham.
Yeah, sounds like Graham.
Is that Graham? Graham, did
Graham, you're listed as caller 01.
Oh, Graham's not gonna be here.
Yeah, sorry, I've been on the phone here for about 30 minutes, but
oh, I'm sorry, I didn't notice you came on. Are you planning to join us in person?
yes, I'm almost there.
Madam Chair, if you're inviting discussion on the motion, I am just glad to say I think the effect of that change, those two changes to the language that's been drafted, makes to me the provision more enforceable. It leaves the definition of discriminate probably to council and the law director, and they can try to figure that out. They could use their codified ordinances in order to do that. And it limits the acts of discrimination to those two particular environments, city services and employment, which I think makes the whole thing much more enforceable as a principle.
Kevin, if based on the revisions we're discussing here, if the city did put this in the charter, would that mean that what Leah's been pointing out about the city contracts, would that now be invalid because there is no charter language that says the city can apply a non-discrimination policy to contracts?
No,
Why
this
not?
does not say that. This leaves, look, you could add city contracting to the list of two right now, city services, employment, you could add contracting. I think that would be perfectly appropriate, because that defines the environment.
But I don't think it's necessary
But
to
no,
add it, but we
but
can add
leaving
it.
it out, I will say, has no effect on the existing ordinance that forbids vendors from discriminating. No effect at all.
Well, and the current charter
Why wouldn't
doesn't
we add
have
it
it.
to the list? That's probably,
You can add it, I'm just saying it isn't
the
necessary.
reason to add it is that's probably the biggest place
Yes.
where discrimination takes
Right.
place.
Right.
Or could take place, hopefully.
Could.
Yeah, and to have that in the charter, in a sense, centers it in the consciousness of, the city going forward. Again, is taking a very progressive view on, we are not gonna do business with people who discriminate.
Right.
I just want to raise the question, it looks like we're moving in, we've made some progress in terms of vendors, contracts, et cetera, okay? But Drew, you raised the issue of when the city awards grants or monies to organizations, et cetera. Is there, I don't have an opinion on it right now, I just don't want to let it be unsaid that we haven't looked at that issue, and should we look at that issue in the same way that we're looking at the contract?
Kevin, would that fall under city services, the awarding of grants and
Wow, that's a good question.
access to city
Probably
services?
Probably not.
Probably not. I mean, that's not how I would interpret it.
Okay.
But it would cover a contracted out city services, right? Like garbage
Yeah.
pickup. It would, like a garbage pickup or services that were contracted out that are still considered city services, they're just not done in-house.
I'm so just I guess the way that I would interpret the provision of city services is the city's provision of city services to its residents or its constituencies. That's how I would interpret it. So that's where the discrimination may not occur. In the letting of contracts to organizations that are going to be providing the citizens services, certainly if the city were to write, this is so far-fetched, but if the city were to say, look, Waste Management Inc., we don't want you to pick up garbage from the elderly, okay? That's a discriminatory act. Certainly that falls under the charter prohibitions. But but I wouldn't necessarily call waste. If the city went to Waste Management and said, we don't like you because your CEO is Christian or Jewish or Muslim, that's not a discriminatory act. The current language of the charter would be, that would violate the current language that you've got before you. Certainly would be offensive. It wouldn't violate that language. Because it's not, the act of contracting is not the same as the act of providing services to your citizens. That make it clear?
Sort of.
So what language could we put in here that would make this apply to contractors?
Well, I'm gonna say, so it's like the first sentence, no act, policy, or practice of the city shall deny equal access to city services, city contracting, grants, or equal opportunity employment. So I'd like to put in the grants because that is a big chunk of the city's money that goes into.
Let me just back up for 1 second, Drew, and suggest that I'm not sure just adding a reference there to the city denying equal access to contracts accomplishes what you intend. Because what we're really talking about is a policy of the city in selecting vendors or entering into contracts. It's a little different. So I don't think you could just slip it in after equal access and have it work. It needs more words.
Yeah, non-discrimination ordinance says no person contracting with the city shall discriminate against. So, yeah, it's a different construction.
Yes, you're quite right, Linda. I mean, we were taught about it kind of falling under city services, but it really needs more language to say, funding any not granting any contracts to service, organizations, businesses that discriminate, but then we have to use somewhere in the line the word discriminate, and then we're back into do we define it or not? Lee, what's
Can we
the
use it without defining it?
well, what's the language there that you were
It's
citing?
I
discriminating.
mean, we use all these other verbs.
Yeah, I know. Well, it was Kevin's decision that we needed to, based on that, discriminate or have the effect of discrimination. So again, we're kind of in the same loop here, if we want to.
Well, I think it's a question of finding the right way to phrase it
Yes, yeah.
that doesn't it may be that it may just need a new sentence.
Yeah.
I don't know, it's hard for me to think off the top of my head on how to work it in.
So I have a question about that first part. Kevin, you mentioned city services, employment, and legislation. Why wouldn't we just list each of those three? Like legislation hasn't been, why wouldn't we say equal access to city service legislation? I mean, I get that's a bit rough, but do you see what I'm trying to ask? Is why legislation is being left out?
Yeah,
Well, probably because if you're talking about the city's activities regarding city services or equal opportunity in employment or promotion, that is all affected by ordinances. The city establishes its policies, it establishes the availability of services. So it all happens through legislation, because that's really how the city does things. So I don't think it's necessary to say that.
Well, actually, what we're talking about, it would be in the first part. We would say no act, policy, legislation, practice kind of thing, because that's where we're talking about. It's like we're not going to deny access to city legislation. So the legislation comes before the verb in that sense. So basically what you're saying is we don't want the city to legislate in a way that would be discriminatory kind of thing.
And I think that it gets a little bit tricky if you think about things like contracts, or you think about things like grants. Cities often have, and I don't know whether our city does, but Lee, does our city have set-asides for minority-owned businesses or female-owned businesses?
I don't know that. I don't know.
Well, I mean, if you're going out for bid,
Not.
I don't know our procurement procedures specifically, but DB, disadvantaged business enterprise, I know is something that you can give weight to.
Right.
So yeah, I mean, and then if you're giving a DB a little bit more weight than others, are you discriminating against people that aren't DB?
Well, and my point is that, and similarly, when the city is making decisions on grants. So if you look, for instance, at the distribution of ARPA funds, one might be able to argue that if you take a specific decision, we're gonna give a grant to this, somebody could say, well, that's discriminatory. Well, maybe not in the whole. If you look at all the distribution of ARPA money, maybe if you look at the whole picture, it's evenly dispersed in an equitable way. Maybe evenly is not the right word, but it's equitably dispersed. So you don't wanna have a cherry picking situation where somebody's saying, this one is a problem, because this one is going to a certain purpose that's focused on one classification, like the elderly. And does that mean you're discriminating in favor of the elderly and against other people? I mean, cities make decisions all the time to do certain things for certain categories of their people. So I just wanna say you gotta be a little bit careful about unintended consequences. And, I think we all have progressive values that would support discriminating in a positive way in certain contexts, whether it's to overcome past inequities or because there's special needs in special segments of the population. So I don't wanna, have a situation where we're hurting things that we really wanna help.
That's my big concern is if you're too specific, just setting up for a difficult constraint. And like the idea that, you the sword cuts both ways kind of thing.
What?
I was just thinking I think that's a reasonable concern. We don't want, and listening into the conversation, it does seem like there are some potential concerns about the sword cutting both ways. I believe we did motion to change the language previously that was seconded. We're in discussion for that motion right now.
Right.
Does that language change accomplish all these goals of making it not dangerous, of doing more harm than good?
Well, I think taking out the motion is a different issue than should we add in contracts and
Right.
grants. So maybe we should vote on the motion and then come back to the contracts and grants subject.
Oh, kind of take it in pieces, do it once, then revisit it.
Right now, yeah.
Yeah, no, but I mean,
Yeah, we'd revisit it right now, right?
well, we don't,
No, I don't mean to be critical, don't get me wrong, I'm just saying.
no, I'm saying we don't have to.
It's excessive, we'll just.
Yeah, we should revisit it right now while we're fresh in the middle
Yeah.
of the discussion, because we'll forget
Got it.
otherwise.
Okay, shall we call the question?
I call the question.
Okay, all in favor?
Aye.
Any opposed?
Abstain.
I think we gotta do by hands then so you can see.
I get it.
There were four
All in favor?
Oh, wait,
Or one.
One favored,
okay, 4,
More?
1.
one opposed, and two abstentions.
Okay. Thank you and thank you.
I've just abstained because I don't fully understand, I think, the legal repercussions of the use of this language.
Oh, taking out the language?
Yeah, or leaving it in. I mean, I understand some of the potentials that have been put forward, but it's not super clear to me.
Okay, so let's go back to the question then about whether we need to address contracts and grants. I guess it occurs to me that if you have a general, we have this general perspective that the city isn't going to deny equal access to city services, then the ordinance that requires contractors to adhere to certain behavior in a way is recognizing that the city wants to be sure that those contractors are following the same kind of policy. So I'm just trying to figure out how you would word something along the veins of what we just discussed that would address the contracting and the grants in a way that gives the city the flexibility to both require that folks comply with the existing ordinance and allows the city to make decisions to use diversity in the granting of contracts and grants.
That's my favorite, so jumping in. I'm trying to think of the examples where the ordinance would compel subcontractors to be nice people. I don't think you can do that.
Well, we have one that requires them not to discriminate, right?
Yeah, that's a broad level,
Yes.
I agree with that, it's a broad level statement. But I hear we're going to try to enforce it.
I'm sorry?
I hear that we're trying to go into enforcing it.
Well, the city would have enforcement powers under the ordinance. I assume they could cancel a contract or they could decline to contract with somebody who doesn't
Yeah, it refers to another chapter that has remedies for this, so there is enforcement of that non-discrimination in city contract ordinance. Refers to the fair practices ordinance, which has enforcement.
So our stricture would be, trying to understand it, our stricture would be if the city determines that discrimination has occurred, they're duty bound to separate that subcontract.
Well, there may be a range of enforcement tools.
Right,
It may not be immediately termination, but I'm just guessing, cause I don't know what the ordinance says.
And I'll go with that, but then gets back to our role. What is our role here?
In the charter?
No, not the charter, but designing this type of statement in the charter. It's going to ultimately redound to the city. What are we gonna put in here that says, city, you are constricted by what we're saying?
Well, good question. I mean, I personally am not sure that we need to put something in the charter about how the city handles the contracts and the grant distribution, because I think as I said before, my concern would be constraining the city's ability to, you know, in an overall sense, have some diversity in the way it's distributing its contracts, but an individual contract may be targeting certain things in a way that we would approve of. You know, not in a nefarious way, but in a way that we would find acceptable. You know, so that's why I give the example of sometimes on construction contracts, a government agency who's entering into a construction contract may say, you have to have a certain portion of the budget allocated to minority-owned businesses or women-owned businesses. That's done all the time in public contracts.
I think the problem we have here is that philosophically, I think that's true, and philosophically, it does seem to be an overreach. However, I think the lived experience is that in the awarding of contracts and in grants and in the awarding of the contracts, that's the biggest vulnerability for people being discriminated against. And we have a city that I thought it would be solved by the direct election of the mayor, where the city council was contracting out everything under the sun. You know, and we're back there now. There's all kinds of contracts. We got a contractor to figure out the $250,000 to the ARPA fund contractor. So I mean, contracting out is what the city does. So if we are concerned about discrimination, we should, I think, address, you know, even in a general way in the charter, something to do with the myriad of contracts that the city lets. And they, you know, I mean, they're always letting contracts to firms in California, you know, that we have, you know, all this. It's just amazing that how many contracts the city puts out. And, you know, it's a kind of a bit, it's like you can drive a truck through this. So I think, well, philosophically, we've got one situation which seems to be logical and makes sense and be appropriate, but the reality is there's altogether too much contracting out in my view, but we let a lot of contracts. And of course, the awarding of grants, we're in the midst of that right now with these ARPA funds. And there's issues and problems around that don't have to do with this, but it's a big problematic area and arena in the city is the whole issue of contracts.
It's kind of an operational issue though, and I don't know that I'm having a hard time understanding how the charter would deal with that in a way that's going to be helpful to the residents and to the government, because it's hard to anticipate what's gonna need to be done in terms of contracting for specific purposes. I mean, sometimes it's best to have people on staff who are handling things, sometimes it's best to hire the expertise you need for something very particular. I mean, the reason there's a consultant on the ARPA contracts is because it's a pretty specialized area of deciding how you're, who you're allowed to make grants to and what all the terms have to be.
Yeah.
And having the city get up to speed on it would take longer than the cycle for the funding. So you gotta hire somebody to help you with that. So I think we have to be a little bit careful about defining, as Roland said, what's our goal here? What is it we're trying to do in the charter?
And this may be overkill, but I dare say if Lee went back and looked at the reports of the city, you don't do a whole lot of minority contracting, because the Croson decision expressly forbade that. So what we'd be trying to do is tell the city, you can't be discriminatory, you have to have some measure of diversity, when federal law says you can't do that.
Federal law doesn't allow it?
Coming out of the Croson decision, what you have are a lot of contracts that try and finesse that.
Mm-hmm.
Set aside some, but there's nothing in law that, I doubt if you'll see something in law that says that.
Mm-hmm.
The Croson decision took care of that many years ago. I used to do minority contracting, study
Okay.
minority contracting. So it's just something that I'm familiar with.
Yeah, so maybe that's a bad example, but I think that we do have in our active ordinance in Cleveland Heights provisions that address how contractors behave, right? And what they're expected to do in their operations. That's already there.
Yeah, the contracting one, yeah.
Just wanna say for the record, I don't think that we should include contracting language and that we should stop at the statement we did and then move on. That's just my opinion.
What did the Croson decision say?
This is a long story, but I'll try to make it short. Minority contracting is based on the fact that someone starts to be discriminated. The Croson decision says you can't use their numbers to then try and mediate that inequality. That in and of itself is unconstitutional because you're actively discriminating against, in this case, a woman contractor, the Croson decision. By the fact that you're trying to do a historic redress, you can't do that. Court ruled on that
And what year, was that a while ago, did you mention?
about 20 years ago.
20 years ago.
So I raised the issue of vendors, and Drew, you raised the issue of grants, so you can speak to grants, I'll speak to contractors. After all the discussion, it's not really terribly clear, but it is, but I do think at this point in time, relying on ordinance to deal with those particular issues would be acceptable to me, because I don't really know how to integrate it into something in the charter. I'm not sure it belongs in the charter. If I don't know how to say it, I can't say I know that it belongs here, right? And I don't know how to say it. So that's where I'm at on that. And so, like Jonathan, I'm saying that I could move on without resolving that.
Well, I'd like to say that I don't know how to say it either, but lawyers do. I think the abuses are the abuse of discrimination is gonna take place probably not so much within our city council, given who we are. That's not what I'm as worried about as all these contracts that get let out to who knows who. That's where these abuses are gonna take place, and I would like to see something that would, if it could be done simply by adding a phrase or a sentence, I'd like to do that, because I even though like you, Guy, I have no idea how to phrase it. Not the remotest idea, but I do think it's where the abuse takes place, and if we care about these things.
So can I ask, Lee, correct me if I'm wrong, but from what I've heard in the discussion so far, we have ordinances in the city of Cleveland Heights which direct the procurement people to consider or ensure that there isn't discrimination in this regard. And I don't know what more to do there. So that's why I'm saying, it's as covered as well as I can see it being covered, but not to impose my thought on you.
I agree with Harriet. I mean, there's another part of the charter that talks about franchises, and I believe we've been advised to remove that kind of thing, but the city does have language, or, you know, up to this point has language dealing with that sort of city contract, and so it's not inappropriate to put it in the charter. And I think, as Harriet said, that a huge amount of city funding goes into contracting and grants, and to not cover that in some sort of non-discrimination policy, I think would be, on our part, an omission. On the other hand, I think that will take some legal wordsmithing, maybe from Leader Governor, that sort of thing. I don't think we would be able to accomplish it at this meeting. To use our time wisely, the commission might want to adopt the revised language as it is and say we will keep that on the table for additions regarding city contracting and grants if people agree to that, so that we can say that the commission, a majority of the 4 people decided to the revised text with that, the sentence taken out and that phrase taken out. We're okay with that, and then we did that, and then we're gonna say, we think we would like to add language concerning city contracts and grants, but we're not legally qualified to craft that language right here. We will refer to our legal counsel and come back to it.
Drew, if I could just comment on the franchises. The franchise language, we were advised to take out the franchise language because it's obsolete. The franchise language relates to a time when cities were entering into contracts with things like streetcar companies or utilities.
Yes.
So it's contracting on a much larger scale. And something that would more directly affect like the entire city. So that's why that language is no longer needed. So a little bit different. I guess the other thing I would mention is, and Kevin, you can correct me if I'm wrong about this, but in the language that you found in your research concerning city charters dealing with discrimination issues, I don't believe that any of that dealt with contracting, did it?
I'm thinking maybe only Bexley. Let me see. Because Bexley had the most comprehensive one. I don't remember it being anywhere else. I'm looking right now.
Kevin, that's Bexley where?
See it.
Ohio.
Is it Ohio, around Columbus? Okay, thank you.
Yeah, I think Bexley's still just provision of city services and hiring. So no, I don't recall. There was
So that's just a point of information. I don't think it's something that you typically see addressed in charters, and which is not to say it can't be, but, I always, and this is just part of my training that was ingrained with me, over 42 years, that if you're gonna draft something, you look and see what other people have done, kind of see what best practices are. You don't just start with a blank piece of paper, and you try to think about why would it be done or not done. And if it's not covered in charters, I guess my guess would be, doesn't need to be, that it's handled on a city by city basis, because I'm sure we're not the only city that has that kind of an ordinance that has rules for contracts.
There's a provision in Bexley's charter, and it's actually more along the lines of an affirmative statement. It says, when issuing all contracts, the city shall give due consideration to individuals and firms owned by and controlled by women and minorities by establishing and maintaining programs and policies which promote fairness and equity.
That's what Roland is saying you can't do.
I'm saying that phrase like that, it's an indicative statement. It's not saying you have to.
Right.
I'm good with that.
And that's in their charter? Or is that an ordinance?
Yes.
The charter.
Charter.
Sure.
What section is it?
Yeah, this is Bexley.
Bexley, Article 2, Section 5.
Thanks.
Thank you.
So there is precedent for some sort of affirmative action statement in the city charter.
Yeah, and I think,
What, you said it's, what is the verb shall or?
shall give due
Shall give due
consideration.
consideration, okay.
That was nice language.
It's great language.
Yeah.
You've been lawyered. Do we have a motion on the table?
No.
Not yet.
Okay.
Yeah, I mean, I thought Drew made a constructive suggestion, i.e. we'll revisit this. So we can move on.
Then let's direct somebody to do something before we leave it behind, or
Well,
accept that we aren't going to.
We're looking for language that would cover city contracts and grants to make sure that the city extends the non-discrimination policy, or whatever we're gonna call it, kind of thing, into the awarding of contracts and grants to make sure that we're not granting or contracting with agencies or organizations or businesses that discriminate.
But that's not what the sentence does.
I know.
The sentence that
Can we
you
just,
just read, or, yeah.
can we just make it a general statement, opening, saying the city shall not discriminate on the basis of race, color, national origin?
We've already decided not to say that. We just voted on that 10 minutes ago.
Okay.
Some of us are concerned about the amount of money that goes into it and social validation that goes into the city contracts and grants. And we want to make sure that they are covered. Lee found something that refers to granting affirmative action basis, not opposing discrimination, but giving preferences to minority organizations kind of thing. So there is charter precedent for something like that. But we're looking at the negative rather than the positive sort of a thing. We're looking at some sort of prohibition on awarding city contracts or city grants to businesses or groups that discriminate.
So do we want to table this issue for consideration at a
Yeah.
future meeting? So
No,
we can move on? You don't want to?
I don't wanna table it, I don't think we should talk about it anymore. I think we should go ahead with the statement and then just move on. Or agree that as a majority that work should be put into it. That's what I think.
Okay, so we can have a motion.
So a motion would be to look into and propose language around anti-discrimination and contracting.
And award,
Grants.
awarding
Awarding
grants.
grants. That would be the motion.
I don't know that you need a motion for that, I might move to approve the language right now that you have. And then you can
Didn't we
just
already
see-
do that?
We did that.
Oh, we just amended it, we didn't approve it,
Yeah,
did we?
right.
Okay.
Oh, I thought we approved
No,
it.
we amended it.
Oh, we amended it.
changed.
We,
We,
I
I
discrimination.
thought we had a vote on the language that this,
yeah,
with amendments, we approved that.
I see.
I thought the motion was just for the amendment.
no,
Oh, was it amended and approved?
It was
It
approved
was
with the
to
deletion.
change it in that way, and then we voted on it.
Okay, sorry.
So Jonathan's motion though really goes to whether we want to come back to this issue about city contracts and grants.
And Lee, you were saying we don't need a motion for that?
No, I'm sorry,
Okay,
I thought you were missing a step first.
Okay.
Does anybody want to second that motion?
I'll second it.
Okay, all in favor?
Aye.
Hands, please. I'm gonna vote no on that,
So am I.
okay, so that passed.
Can I just ask, there was no discussion in there, can I just, who are we asking to do that? Who is it that we,
We will ask
Lee.
Kevin, we'll ask Kevin to suggest something.
okay,
Oh,
I don't,
No, I'm sorry, sorry, you know what, I have my hand raised in the meeting, I will unraise my hand. The reason is because I was having a lot of difficulty hearing you all, I'm sorry about that.
Should we bring the
I
mic
think it's the ambient,
It
it's
doesn't
the microphone in the room, it's not picking up on some of this as well.
Okay,
So Greg, I don't know if you have the same issue, but maybe it's just me.
so do you have a question, Kevin?
wait a minute.
Lean in when he speaks. Oh, that might be it. Okay. Anyway, I'm glad to take a stab at it. Here's my only question, and maybe I just ask this of Drew right now, since Drew has been an active drafter. Do you want me to take a stab at language that both forbids the city from discriminating in its award of contracts and forbids contractors from discriminating, vendors?
No, I think
Or do you want me,
what Roland said, we can't reach into other businesses. That's that's not, where we do our enforcement. Our enforcement would be in awarding contracts, and if we get complaints about discrimination in our country, to withdraw them. If whatever
That's
the
what he-
legal term would be for that, to terminate a contract.
But Drew, that's what we do now. We have contracts that prohibit vendors from discriminating.
Yes, exactly, and we're talking about putting that into the charter.
Right, but so it is on both levels. It's the city won't discriminate in awarding contracts, and the city will require that vendors not discriminate, right?
That's what I'm asking.
That's what
You
I'm
want me
asking.
to write language that does both of those things?
Well, I wanna make sure that that's what the city is currently doing.
The non-discrimination is no person contracting with the city, so it's not about the award of the contract, it's about discrimination.
It's about what the vendor does.
About what the vendor does.
Well, apparently, Kevin, I apologize, apparently the city already says that businesses that the city does business with cannot discriminate, and so I guess we should put that into the charter as well.
Okay, I'll take a stab at language that does both in the same sentence, and I'll have that for you shortly.
All right, and would it unnecessarily complicate Kevin's job, but if people are feeling, right now, if we think that that might be a bridge too far for the charter language, should we ask Kevin to give us an alternative sentence that does not include the businesses themselves and their discrimination practices?
No, let
And
him,
we're gonna leave that out?
he's agreed to.
Okay, all right. Okay.
Can we just clarify, is that contracting and awarding grants?
Yes.
Both?
Yes,
It's
so we're
both.
going for contracting and grants. All right. Thank you.
Got it,
Thank you.
Okay,
thanks.
so we're gonna put aside that topic. And we're going to go on to the chart of points.
Can we actually go to public comment?
Do you have comments?
Absolutely none. Hi, Kevin, it's Donna Colas. What is she doing?
Oh, hey, Donna, how are you?
Great.
Well, welcome.
Thank you.
Okay, so we're going on to the chart that Lee distributed. Now, I wanna suggest that on my copy of the chart, no, it's this longer chart.
Final thing is,
I wanna suggest that, I went through this chart and numbered the questions so they would be easier to refer to. And I also identified about 10 of them that I think we've already discussed. So we don't need to spend time on those today, but I'll mention that as we go along. So for instance, I think we've talked about the first 3 already. But if anybody wants to talk about them, speak up.
Is this in today's packet or?
Yes,
The big,
very
the big staple font,
Biggest.
My
the
notes,
tiny print.
my notes.
I do
It's
not
the agenda
have-
with my
I
notes.
do not have that.
Well,
That might be one of these.
Thank you.
Still is best.
Everybody have their document in front of them?
Yep.
Okay, so, as I said, I thought we had already discussed 1, 2, and 3, or we'd gotten advice on it somewhere along the line, but if anybody has any comments on those, please speak up.
And so that's home rule, charter preamble, references being legally necessary.
Right,
And crystal clear.
okay, hearing no comments, we're moving on.
Wait a second, I'm sorry, can you, I just got my own copy out. It was
The first 3,
1, 2, and 3.
okay? Okay. Item 4 is the land acknowledgement. So there's a response here on the land acknowledgement question. Does anybody have any questions about this?
Just for moving forward, if Grim's willing to undertake the assignment, if he would draft a land acknowledgement that could go into the charter, I think it would be good to have some language in front of us to consider this now that we know that it's not particularly a liability either way, kind of a thing. If Grim's willing to do that.
Well, I think the statement here says that it introduces a legal risk that isn't currently there, so I don't think it's quite accurate to say that it doesn't create a liability?
No, it says it's unlikely to create a legal liability. The first sentence says it's unlikely.
And the last sentence says, however,
Yes,
it would introduce.
there's always.
Legal risk.
Right. Yeah. I've been reaching out. I've reached out to the Lake Erie Native American Council and the Cleveland American Indian Movement to see if they have any thoughts about whether or not it would be worthwhile to include this in the charter. So, I mean, I'm definitely willing to undertake that. Just communicating with those regional organizations and seeing what they say and reporting back.
So you have reached out, you just haven't heard anything?
Yeah, I've reached out, but I haven't heard back yet.
All right, should we move on to the next item?
I mean, is one gonna get drafted or not?
I'll draft one. I mean, I mean,
Can I make a suggestion? You're gonna come back with information from them about what their thoughts are
Yeah.
before we ask you to put time and effort into something that Kevin will be asked to look at. Let's just get that feedback. That would be my suggestion. Let's hear what they have to
We
say.
have language.
Yeah, I'd like to go both.
Yeah, let's do both.
Get feedback, and based on that feedback, draft some language kind of thing, and then if he has time, submit it back to the organizations he's in touch with to get their approval. And then, because I'd really like to have language in front of us the next time we discuss this.
yeah, I won't spend too much time on it, but no hard feelings. I'm not gonna draft this with any expectations. So
Wait a minute. You're not being clear. What are you saying here?
I will, once I hear back from these organizations, if they think it would be valuable, I'll draft some language to bring forward. And then we can just discuss it with whatever language and their comments.
Do you have any sense of when you're gonna get back to them?
No idea. I'm actually, I just reached out to like the organization emails, so I'm not sure how monitored they are, but I know some individuals who are involved with the groups, I can contact them directly, which I haven't done yet.
Well, I have a contact that I could contact as well.
Okay. Great, yeah, that would be awesome.
And although I can't imagine that they don't have a feeling about this, if they didn't have a feeling about this, that isn't a reason not to put it in the charter anyway.
Good information gathering.
Yeah.
I just wanna note that the fifth one asks whether other cities have adopted land acknowledgements, and the example we have is Portland, Maine.
Mm-hmm.
I'll just add, I did, as I was prepping for this meeting, locate New York City has one as well.
It's in their charter or ordinance?
It's preamble to their charter.
Okay, thank you. Oh, it's in their preamble, okay.
That's what we're talking about too, right?
Well, we don't know that.
Well, I mean, yeah, Portland, Maine's was in the preamble.
Oh, we were. I thought we were assuming that that's
We
what
could
it was.
just think,
Part of the conversation.
Part of what
I hope you'll forgive me, I don't know the legal term of our land acknowledgement. All I can tell you is that the New York City language from its charter looks a lot like the Portland language.
looks a lot like.
The Portland.
The Portland language.
Okay. Thank you, Kevin. I appreciate you doing that.
And I do like the term unceded territory, because I think that creates the historical context rather than land belonging to or formerly belonging to or this or that, because a lot of Native Americans do not feel a sense of ownership of land. It was a sense of sort of unity with the land. So unceded territory, I really like that phrase.
Except wasn't there some place in which it said that some treaty of
Yeah, there was a treaty.
was ceded. It was
Shucks.
But yeah, we can look into that.
Yeah, that's the historical element of Ohio that may be different from Maine. I don't know what happened in Maine.
And this, the other one was this in Oklahoma.
Maine was mostly the infected
I don't know, but I think
smallpox
that,
infected.
I think the treaty has an impact on the situation in our state.
Again, appreciate Graham doing the research, and I think it's important that we don't do this just as a way of virtue signaling, that we try and make it meaningful to any Native American organizations or individuals who are still present here, so that it's reality-based rather than just performative.
I agree with you totally on that, and I found it interesting when I spent a few minutes on Google looking up land acknowledgement. The first several examples that came up were colleges and universities who had made statements. And then I hit a string of comments from Native American people saying, well, that's all well and good, but when are you giving us back our land?
Yeah,
So I think we have to be very careful about this, and I think there is a real impact of it that we can't just glance over and say this isn't gonna cause any harm. It's got significance, so I think we have to think about it very carefully. And as, based on what I know right now, I am totally not in favor of this. But I know we're not taking a vote today, so that's just my opinion. We ready to move on to item 6?
Well, just let me put out my opinion. I think that even though that's the case with every piece of land in the country. And I'm from I actually live like very close to the heart of the Six Nations territory, and it's not gonna happen. They would take back the whole country. I don't think this unlikely is an understatement. They have claims on every single piece of property practically in the nation. And they've had them for years, they've known it for years, we've known it for years, nothing has happened. So I think it's exceedingly unlikely, exceedingly squared unlikely.
Thank you. Any other comments on that? Okay, item 6. So this affects Article 1 in our text. Can you pull that up, Lee?
Yes.
Because my question about this is, based upon the answer that we got, do we take out the second sentence, which is the one that relates to annexing? Can you highlight the second sentence?
When I find it, yes. There we go. Here's an annex. There we go. Boom, boom, boom.
Starts with however.
Thank you.
Can you share your screen so I can get it?
Yep.
You're
Let's
up
do
too
that.
high.
Yes, I gotta, too many things at once. Okay.
It's the fourth line from the bottom. There
Yeah,
you
so
go.
for this piece. But this is all one sentence, isn't it?
Now start with however. Doesn't however start a new
Oh,
sentence?
here's annex up here, that's why.
Yeah,
That's what threw me off. There's annex mentioned above.
Excuse me.
Oh, sorry. So annexed here, but there's also boundary and annex up here.
Yeah, so this has to do with matters authorized by law. So I think it's okay to leave that in, subject to legal opinions here, but we should take off this last sentence because we don't have that authority, as I understand it. Am I right about that, Lee?
I think so, yeah, I think we commented on that.
Well, that seems open and shut.
Does it
Can we
make
move on?
sense that we take that sentence out and then we're okay?
I think you could.
Alright,
Kevin, do you have any thoughts on that?
I don't think it's necessary. I also don't think it's harmful.
Right.
So which makes it classically superfluous to me. It does not, to me, diminish, if you were to remove it, it doesn't diminish the city's rights. If you were to keep it in, it doesn't strengthen the city's rights.
Okay, why don't we just leave it alone then?
Well, it's just
Well, in our quest
unnecessary.
for simplicity and avoiding,
I could go either way.
yeah,
Let's take it out.
Do we have a motion?
So moved.
I'll second.
Any discussion?
question?
Yep.
Call for question then.
All in favor, say aye.
Aye.
Any opposed? Any abstention?
I'll abstain.
Abstaining?
I've,
All right, so we have 1, 2, 5 yeses and 2 abstain?
can I request that there be a little bit of time for discussion before we call a question, please?
Weren't we discussing it?
Do you have questions you wanna discuss?
No, I just,
Or just as a?
So it's just, it's only, what I would like to have said, which I think, is that there may be a series of things that we as a charter review commission may say, we really wanna clean up the charter this way, these things don't belong in the charter, yada, 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 okay? And that would end up being a bucket, you know, I imagine would end up being a bucket. We just say, we just wanna clean up the charter because these things don't make any sense. And this could be one of those things, just to simplify what we're doing, you know what I mean? Just to, so when the next commission comes and looks at this stuff, they don't have to ask Kevin to do the same thing, all right? Cause it won't be there. And so that's what I'm
So
suggesting.
you would like us to categorize it as a simplification?
Yeah, a correction or simplification, something of that nature. And if we end up having enough, and if they're important enough, and they aren't collectively considered superfluous, which I can certainly see that possibility, but if they aren't collectively seen as superfluous, then we would say, we have a bucket, we just wanna
Well,
clean things up.
Actually, what we voted on, don't you have to vote on calling, if somebody calls a question, don't you have to vote on that or not?
No.
Or do you just immediately vote on the substance?
You just vote.
Okay, alright.
Yeah, so that's what where I'm going, because I think some of the things
Okay, that's a
like,
good point.
in my discussion about the budget stuff, you'll see something similar to that. I mean, I'll bring that up, so that's all.
Okay.
Kind of like with franchises, would be another example.
It'd be another thing, so they don't have to, the next group doesn't have to do the same thing we're doing, which is just a waste of
Right.
time and money and effort.
But as, we just voted, so it's out, right?
Well, it's out, but I think his point is that we identify it as being a potential modernization simplification bucket,
Okay.
right?
But it's out either way.
Yes.
Well, I think that, I mean, we could combine that in the, we're talking about there's an update the language bucket. And
Yeah.
we could define update as, you know, modernize, simplify, that sort of thing, you know, changing Roman numerals to Arabic numerals, that kind of stuff. So it's perfectly legitimate. I'm just saying, like, let's see if we can fold that into the update language bucket, because I think that it applies.
I think that's what you were saying.
Yeah, that's fine, that's good. I'm only, we aren't doing anything when we say take it out of the charter, right? We're making a recommendation to council to do these things, and we're gonna give them some effective way to make those things happen, so.
Yes.
And that's what I brought up. That's all.
Okay, thank you. Okay, are we ready to go to 7? Okay, so item 7 is referencing a provision in the charter in 2.1 and 2.2 that I think now doesn't have a reference specifically to home rule. So the question was, should it refer to home rule? And the answer is, we don't need to add that. We can leave it as it is in the draft marked up by the 2019 Charter Review Commission. I believe that's the thrust of this. So any comments, questions, discussion?
Well, this was that, we don't have to say 2.1, this form of government, right?
Well, I think it's 2.2 and what's on the screen was 2.1 in the 2019 recommendations. So this says 2.1 of the 2017-2019 draft.
Okay.
Again, we don't see the current charter up here. This is the proposed 2019 revision.
Yeah.
So we don't know what the current charter has in this, because it's something different. So I wanna make sure we're basing our decisions, including the current charter language, because they revised this.
But Drew, we had already looked at this when we went through the 2017-2019 charter and decided to accept their changes, but it was subject to getting this question answered about whether there needed to be a reference to home rule.
Actually, I apologize, but we did not have any process in place for that. We only established our process for making decisions as a group maybe a month or 6 weeks ago. I know we read through this and said, yeah, that's acceptable, but as far as voting to adopt that as our new language, we didn't have that process in place. We were going to revisit all these things, and to my recollection, we were going to actually do them side by side with the current charter to see where they were. So I agree with what you said, but I don't feel that we had the actual process in place saying this is what we're going to do.
Well, I will say that we looked at this provision and we said it's okay, subject to having advice on whether we needed to add in home rule.
And compared
Now-
to the current charter.
But this compares to the current charter.
Yeah, the current charter is in black. So there's only one, under Article 2, there's only powers, that's it.
I don't think you need to
So
read
it's
it. The
the-
only question was whether we needed to add in home. No, I can't see it. You have to walk up to the screen to see it.
Really, I can make it bigger. Anything?
That helps, thank you.
Yeah, that helps.
Yeah, that's good.
Alright, ask and you shall receive. Okay, so they added the 2.1 form of government. And then in black, this is what currently exists.
Yeah. And again, the only question that is relevant from this chart is, did we need to add to 2.2
And the-
any reference to home rule? And the recommendation is,
No.
we don't need to do that.
And so with the removal of 2.1, the first sentence says is not necessary, would that fall under the correction simplification?
Well,
Because you know,
it's saying that we don't need to say it.
Mhm.
It isn't necessary. I would say it's helpful, and it doesn't hurt anything to leave that sentence in that says we're a mayor council government. But I don't feel real strongly about it. If people wanted to delete it, I could live with that. I'm not gonna
I agree.
die on that hill.
So as the one who came to this and just read it from the start, okay, that would be very helpful if I was in 10 years looking at this charter. That would be a very helpful statement for people to read because it gave context to lots of other things that I read. So I like it.
And that 2.1 is not in the current charter.
correct.
So that's an addition from the 2019 thing.
Right.
They split up the Article 2 into form of government and powers. Currently, the Article 2 only has powers. That's all that's, and I'm not even sure what the redlining and underlining means kind of thing.
That's
Language that was added by the 2017-2019
So
Charter Review
the
Commission.
black text is what's in the current charter.
That's right.
I would agree with Guy saying that defining what the structure of the city is very helpful because that's, otherwise it's assumed something or other.
I agree with that, yeah. Do we wanna vote on that?
what's the motion or what's the vote?
Okay,
Votes to keep it?
Can we go back to that 2.1? So I would move that we, with our new process, that we adopt Article 2.1 for our, part of our recommendation of updating charter language.
Second,
Second.
Madam Chair,
any discussion?
Yes, Kevin, I believe, or Greg, I'm not sure.
Roland seconded it. Craig can't do anything because he's on the phone.
But it's somebody has a
Discuss.
question.
I think those are facilitated.
Discussion?
oh, I did, I'm sorry, no, that's Kevin Butler, I wanted to see if I could just ask a question in discussion before you actually take your roll call.
Sure.
Do you wanna, I recognize that it said this in your current charter, but do you wanna just tweak that slightly by saying be known as a mayor council form of government?
Yeah, yes,
Be known as mayor council government doesn't sound like it.
No.
Sounds like it's missing an article.
Form of.
yes, yes.
Even that works better. Okay, that's all. Thanks.
Is that
Do we have a motion?
the as a
Form of government.
Thank you.
Do we have a motion for that amendment?
I move.
Second?
I'll second.
Any further discussion?
Call the question.
Questions?
So then the question is to adopt this now as our approved text for the, going forward in the charter.
As amended.
Yes.
So the motion is adopt as amended. Do I have a motion for that?
Okay, I'll move it. Yes.
Second?
Second.
Any further discussion? All in favor?
Aye.
Any opposed? Okay, now moving on to 2.2. The question is, do we need to change it to add reference to home rule? The answer given by the law department is no. So the motion would be, and I will make a motion that we accept this as on the screen.
Okay, I'll second the motion, then we have discussion.
Yeah. Discussion?
Linda, it's Kevin, I'm sorry. I think Lee perhaps just wanted me to take a second look at this as well. And I very much trust Lee's guidance to you. All of it is good guidance. And I agree with this one as well. Lynn, I think you set it up nicely earlier. Franchises were historically the opportunity to use usually public rights of way in order to provide highly regulated services to citizens,
Right.
such as cable television, telephone, busing, public transportation, that is.
Kevin,
All of which-
just one question.
Go ahead.
We're on 2.2, which doesn't reference franchises, I don't think.
Oh, I'm sorry. Oh, gosh, I'm sorry. I thought you were on franchises. I apologize.
It's okay.
Forgive me.
Yeah,
I thought you were past that.
yeah. Can you see the screen?
I left you and went to my own screen. I'm sorry.
No, it's fine. I just we can't see you and see the charter at the same time.
I can see it now.
Okay.
Okay.
Forgive me.
Just a point of parliamentary procedure, I don't believe that we need to vote, unless there's, like someone has any sort of dissent. So in a situation like this where there's no real discussion about it, we can just say adopted by consensus for the motion. We could vote, but we just don't need to.
Well, I just don't want to have any questions about whether we did it or we didn't do it later, because there seems to be some confusion about that, because I think that's what we were doing earlier on. But in any event, do we have any further discussion? Okay, all those in favor?
Aye.
Any opposed? Okay. So now we're going on to item 8, we don't need to talk about because we're not doing hybrid at large.
And Linda, not all of us have your numbers, so if you could just briefly indicate what the item
8 is hybrid at large ward elections. Item 9 is the franchise provision.
We're at the franchises now, Kevin.
So Kevin, if you want to talk about franchises, this is your time.
I'm not going to repeat myself. All I'll say is largely that authority has been usurped by the state. And so with respect to, for example, the granting of cable franchises, state has taken that over. Now they're called video service authorizations, and municipalities are no longer permitted to enter into franchise agreements with cable providers. Now we have, and most municipalities don't have highly regulated industries just within their borders, such as busing. We now have a regional transit authority, for example, that does all that.
Okay.
So I would think that it is appropriate to remove franchising language from your charter, because it's just not something that cities do anymore. To the extent that a city would need to do it, grant a limited franchise for some reason, it can most certainly do so by ordinance.
Kevin, I have a question on that. I'm on the board of the Senior Transportation Connection, which contracts with cities to carry seniors to around the, to their appointments, et cetera. Cleveland Heights currently does not have a contract with STC, but I'm hopeful that we will one day. And so would that be an example of a franchise?
No.
That Cleveland Heights enters into with, why not?
It'd be just a
I
contract.
don't believe so. Only if the city for some reason were to turn senior transportation into such a highly regulated industry that it believes only one vendor should be providing service to seniors in the city, and no others should. So that's typically the hallmark of a franchise. So the city has decided for itself that there's only going to be one cable company that serves the citizens of, for example, Cleveland Heights. That just doesn't happen anymore now. And so the city, in my view now, would say, if we need to engage another senior transportation company in order to supplement the services of STC, we'll just do that. Or we'll engage a cab company to make individual trips, or et cetera, et cetera.
Okay.
It's not such a highly regulated industry that I would ever consider that to be franchise worthy.
Okay, thank you.
One quick question I have is, so I noticed the revisions, we mentioned public utilities and franchises, those are synonymous or are they different?
Which two?
Public utilities and franchises.
Well, I think a public utility is a type of franchise in the sense that, as Kevin said, it connotes exclusivity.
So the reason I'm asking is under 9 on the chart, should the charter retain it? It's, we could remove it because regular other ordinances. If I were to say, yes, let's remove it, would I say take out section 3.10 as well as public utilities, or are we only discussing franchises?
Kevin, I think that's for you and Lee.
Well, to make that clear, the current charter has a section 9 that just talks about franchises, it's one sentence. The 2019 proposed taking that and making it something completely different than 3.10, public utilities and franchises with all that additional language as you see. And I know they had a rationale on that.
So do we want to retain it for public utilities to drop the reference to franchises?
That's the question, there you go.
Well, wouldn't it relate more to franchise? I mean, as a practical matter, it's not really gonna come up in public utilities. But it might come up in franchises, right?
Well, the note here says we should consider removing provisions related to franchises. So that's, that one there.
Because it's regulated through area through ordinances, Lake would remove theirs.
Yes. And this language does say council may by ordinance, public utility or other franchise. So, so if we're going to reference franchise in the text, we better keep franchise in the title kind of thing. This is a big block that was moved around under 2019.
So Kevin, here's my question. And the lawyer people. The statement about franchises, does that apply to public utilities in regards to moving the provision, it's regulated through other ordinances?
Yeah, you kept that language in as it's been suggested. It's perfectly fine to do so. And I think actually Lakewood's charter, when the comment said Lakewood removed its franchise provisions, I was there at the time. Lakewood removed its highly prescriptive language on how to grant franchises, how the city government is going to grant franchises. And I think instead replaced that language with something along the lines of what you're looking at, which is language that summarizes when and how the city can grant franchises in the future. So it's perfectly fine to adopt the language that you have before you. You have a provision in the charter that says, hey, the city council can do franchises. It's not gonna harm or hurt anything.
That helps, thank you.
Yep.
And I'm noting here that middle of the page there, rates to be charged for product and any other terms considered by council conducive to the public interest. So back when we were talking about can the city do something about city contracts and grants considering non-discrimination, that could be covered by the conducive to the public interest if we want to make sure that the charter is internally consistent with itself, if we adopt language along those lines.
So I think what I'm hearing is that we don't need to, it isn't necessary to take out the reference to franchises. We could adopt this language and just go with that.
Yeah, so I motion to adopt this language. Lee, did you?
No,
Okay.
I was just gonna read it.
Do I have a second?
Second.
Any further discussion?
Just to note that this creates a new section in the current charter. Section 3 currently is about removal, so this will be moving stuff around.
What's it numbered in that draft on the screen?
It's in 3, but it's now just 310.
Yeah.
So
I'm
it
not
would,
sure if that's the, yeah, okay.
Oh, no,
Drew, thanks for mentioning that. I would say that when we go through, we're gonna have to do all the numbering checks and cross-referencing checks so we can make sure that it's in the right place.
Yeah, it helps me to track it because then I know that we're really moving large blocks around and creating. I'm not sure where the section 3 removal is going to end up at this point, just so I can kind of note that everything is in flux.
Okay. Any further discussion, questions?
call for question.
Do you have any questions?
I don't.
Okay. All in favor? Any opposed? Okay. Moving on, item 10. So this is the issue of whether Council President Pro Tem is provided for by ordinance or rule. So there is an ordinance. This language was recommended by the prior Charter Review Commission because it has some additional features that aren't in the ordinance, including specifying that the President of Council prepares the agenda, and it addresses how a President Pro Tem is selected. So my suggestion would be we keep what's on the screen except delete the very last, I think there was a sentence in here that referred to the city manager, and that needs to come out. It may already be out on the screen. You scroll down. Is it still in there?
I have no idea.
Number 1, shall ensure that evaluation of the city manager is completed at least annually.
So, I don't think there's a corollary provision about, reviewing the city administrator, is there? Let me just look at that.
Seems like the city administrator would fall under the mayor's.
Yeah, I don't think we need that sentence.
President, council, or in the president's absence, the vice president shall be recognized as a non-exclusive representative of the city for ceremonial purposes.
I think I have a recommendation to remove ceremonial purposes because it conflicts with another article that makes the mayor representative of the city.
Yeah, I think that sentence has to come out too, because that's no longer, that relates back to the city manager form of government.
So you can just cut that whole thing.
So you take that sentence out too. So we've taken out 2 sentences. Does somebody wanna make a motion to accept that?
So this is taking the place of the current section 11, which is quite short. Does this still have so if you can see the black is now a very small proportion
Can
of.
you make it a little bit bigger?
So the black language is, with the black text is what's in the current charter, but if you scroll down a little bit, you can see that quite a lot of text has been added. It's almost twice as long now.
Well, and this is what was all the previous, the lined out, this is all what was removed.
Right, yeah, but then all this has been added.
Yeah.
That part.
Linda, did you say why the 2019 commission made a change?
They made a change to specify that the president of council has the responsibility to prepare the agenda. And it provides for the president pro tem, including how the president pro tem is selected if the president and vice president both happen to be absent.
But we don't know why they did this.
They said that they thought they were of a character that ought to be dealt with in the charter.
Oh, I see.
Rather than in like just the rules governing council that council sets.
Yes.
And what they said specifically empowers the president, in the absence of the president, the vice president to set the agenda. It creates the office of President Pro Tem to preside at council meetings from which both President and Vice President are absent, and specifies terms of selection. President Council must ensure annual evaluation of the city manager. Well, that's the stuff in the ceremonial is what we're taking out. Here's the language if you wanna see what I just, about their explanation.
Oh, I've got, is that the same as this?
No,
Oh,
this is the walkthrough from the report,
Oh, okay.
so we don't see why they did it.
Oh, okay,
That's what I just read.
okay.
But that was just the why they touched it. I do wanna note it's 12:04.
Oh, okay.
Oh,
Yeah, the current charter doesn't have any provisions for pro tem, it doesn't talk about setting the agenda or anything, so that the clarifying and more specific language in this makes sense.
I think I had a comment on that.
There's an ordinance that deals with the president pro tem. But there isn't an ordinance currently that says that the president of council or the vice president presents the agenda.
so anyone have problems with the language?
Is it okay with putting this into the charter then, or is that something that people think should be done by ordinance?
I think it's fine to put it in the charter.
How about a motion to approve the language as amended, removing the final two sentences?
I think that's one sentence in the last thing.
One sentence.
It's just two like Romanettes.
Yeah, well, just in the strike through.
But we already took out another sentence that referred
These,
to,
everything highlighted,
there was a city manager sentence that you
Yep.
took out. Oh, it's all on that same one?
all in the same, yeah. It was city manager 1
Okay.
and then ceremonial 2, so it's the whole.
Alright, so the motion is that we approve what's on the screen except for the last sentence. We have a second
Second.
discussion? Questions? All in favor?
Aye.
Any opposed? Okay. Do you wanna take a little break?
Yes,
Take a 10 or 15 minute break? What's your pleasure?
15,
15-minute break?
or like 12:20, ish,
Okay.
that work?
All right,
Oh, I might get some more coffee.
okay.
Is that coffee cold?
It's warm.
So,
Ish.
we're on to 11, I think, right?
Moral turpitude.
Perpetuity, yes.
So this applies to section 3.3, and our question was whether there was a definition for this, and the comments suggest a change that may be more understandable to our eyes and ears. So I think that's worth considering, but the language would be for conviction of an illegal act that reflects adversely on the council member's honesty and trustworthiness. So what do you all think about moral turpitude versus a change in language?
Well, Graham found some language that we all approved of that dealt with ability to fulfill roles in office kind of a thing. Do you remember that?
I don't remember the specific language.
Yeah. And I don't know if we captured it or not.
I don't remember that, did we talk about it?
Yes, yeah, it was, we were talking about moral turpitude, and Graham found some language either in a city charter or someplace that had different language that referred to convictions or something like that that would affect an elected official's ability to function in office. That seemed like not moral judgment, but strictly, basically, can that person still do their job? And I think a number of us found that much better.
Well, let me suggest that if we wanna go back and look at Graham's suggestion, maybe we should put the question of substitute language aside and just for now acknowledge that we got input on this. And then Drew, maybe you could dig that up for our next meeting and we could talk about it further.
I would like to, while I agree with what you just said, Linda, but I just wanna put in a plug for moral turpitude. We have a president of the country, we had a Senate, a House Majority Leader. Of course, they were both convicted or indicted, but I mean, you've got, the Trump is an example of someone who until recently he hasn't been convicted of anything. Moral turpitude, I would rather have the council decide that it is mostly left to council to define moral turpitude when considering expulsion of a member. I'd like to leave it that way because we have a new era in politics. It's not just authoritarianism that's coming, but there's a nastiness, a viciousness, a disgusting. Lauren Boebert is an example of someone who is not fit to sweep the streets. And so we have a new era of politics where you have all kinds of unbelievably unsavory people running and winning election. And it hasn't trickled down to Cleveland Heights yet, but I want to emphasize yet because it certainly has affected civility in Cleveland Heights. It's affected all kinds of behavior. So I just think that we ought to keep in moral turpitude. I just want to make that statement.
Well, Harriet, one thought I have. If you look at the comment here about how the Supreme Court in Ohio had defined moral turpitude, characterized by baseness, vileness, or the depravity in private and social duties which man owns to his fellow man or to society in general. I'm not sure that moral turpitude necessarily captures what you're concerned about. If that's your standard.
Lauren Boebert and Matt Gaetz?
Well,
This is Charlie.
See, the problem I have
I'm just wondering.
about them defining it is there was also Clinton and the whole sexual act thing, and people said that was against moral turpitude. It had nothing to do with trustworthiness or honesty. And he got crucified.
so let me
it can also be
suggest.
weaponized.
Yeah, let me suggest again that maybe we defer this choice of language for a future meeting.
I think we have to talk about it 3 more times before we do that.
Well, I was thinking about the next meeting.
The only other suggestion I have is you might wanna consider reconciling the grounds for removal of the mayor in 4.9. His refers to felony conviction. But take a look at those two together, see if they need to match.
Yeah, good idea.
That's a good idea.
Yeah, I think it makes sense to table moral turpitude as well as reconciliation with 4.9 until a future meeting.
I wanna,
Yeah, and I agree with you, Linda. I just wanted to put a.
do we have a second?
I'll second.
Do we have discussion? All in favor? Any opposed?
And Graham was still gonna look for that language.
Have that as an action item.
All right, yeah. Harriet, I
Yeah, let
agree
me
with-
suggest we do that. We discuss this at our next meeting, just to try to get it settled. Okay, so we're gonna move on to item 12, which we've already dealt with.
Just a special election.
Yeah, that's filling vacancies. And then item 13 is, so this has to do with the language we agreed upon for filling city council vacancies versus mayoral vacancies, and there's a comment here about the time periods differing. I wanna just note that the difference in the time periods relates to the fact that we have, under our current rules, a primary for mayor. So if ranked choice voting were adopted, we wouldn't have a primary for mayor. But that's the only reason that there's a timing difference. So I just wanted to remind people about that.
See, and I also took in there towards the end, but it's merely being unusual doesn't mean we need to change it.
Right.
So maybe we leave this be, solidify the ranked choice, and then that would, actually, we know we're doing ranked choice, so what if we just,
I think the way it would work technically is if we have a separate bucket for ranked choice voting, one of the things in that bucket would be to adjust this feature.
I see what you're saying, that makes sense.
Because I think the ranked choice language already has something about when people filed, so I think it would kind of take care of itself in that context.
So I guess, like, do we need to do anything with this, or
No, it's just a point of information.
that makes sense?
So since we have voted to include ranked choice voting in our final version. Or I guess maybe we actually have, I think.
Well, subject to
Just
agreeing on language, yeah.
Right. So we would include this associated with that, okay, that makes sense.
Okay, so we'll go to 14. So this question really was simply, why does the charter discuss salaries and how do other charters handle it? So we do have language from Roland on salaries, but I'm not suggesting we look at that at this moment. We're gonna do that hopefully later in this meeting. But I think this is really more a point of information. And we have the very helpful table that Lee attached that tells us what other cities do about salaries. And, you know, we have here a little explanation about why these things are addressed in charters. But does anyone want to discuss that any further at this point?
I found the chart daunting. It's like pages.
Okay, item 15. So this has to do, the question stated here was whether the mayor could be excluded from city council discussion or city council meetings, and whether the charter could be amended to exclude or limit the mayor from participating in discussions during city council meetings. I think actually the way this point came up was more narrow. It had to do with whether city council could exclude the mayor from executive session. And I believe, well, because the context in which it was presented to us was if city council, for instance, is discussing their own determination on whether to make an appointment, that's a city council decision, so the thought was the mayor didn't need to be in the room for
So
that.
you mean committee of the whole by executive session?
I mean
Or-
executive session. So
Okay,
there's a
separate from
difference
committee of the whole,
between a committee of the whole meeting or a city council meeting and an executive session, because executive session, the public's not in the room.
And then the public could be the mayor or anyone else versus an
Yeah.
executive where only
Yeah.
upon invitation.
And there are some executive sessions where I think probably everybody would agree, even everybody on city council and the mayor would agree the mayor needs to be in the room. But this was really a more narrow context. And I think, Kevin, I think you made a suggestion on something that it related to the executive session. I don't remember whether that was circulated.
You're muted, Kevin.
Oh, wait. I think that, okay, now try. It's not you, I think it's me.
It might be me.
Nope,
You sure?
it was
Can you hear
me. Yep,
Yep.
we're good now, thank you.
Okay, great. My thinking was that it would be extremely unusual for a city council to want to adjourn into executive session, which is a meeting that occurs within a public meeting, but that happens outside the viewing of the public. As to say, during a public meeting, council may adjourn into executive session in order to discuss certain things under the revised code. It would be unusual for council to adjourn into executive session and specifically ask that the mayor not be there. Most of the time, the mayor would be there because oftentimes the things that are discussed in executive session, that's a limited number of things provided for under the revised code, are things that involve the mayor's administration anyway, such as the purchase of property, sale of property, litigation matters, and I'm generalizing those matters. But there are some instances in which it would be possible for city council specifically not to want the mayor behind those same closed doors. And I provided a couple of examples, just, and I'm not sure they did reach you, but those examples could be, for example, if someone involved in the government of the city, some employee or official, were accused of wrongdoing, and it would be possible that that person were acting in cahoots with the mayor. city council wanted to adjourn into executive session to discuss the employment of that particular employee or official, it could do so, but perhaps not want the mayor in the room. That's one example. Another example could be that council could, if the council wanted to have a candid conversation about maybe a controversial nominee, mayor's nominee for a director position, and wanted to have a conversation among themselves about the employment of that particular nominee, the appointment of that nominee. Without offending the mayor or having the mayor in the room, possible council would want to do that without the mayor being present. Those are really rare examples. I don't ever recall that happening, but at its core, executive session is a closed-door meeting of the legislative body, and whomever the legislative body wishes to have present in the room. So, to the extent this might be an issue because the current charter says that the mayor may participate in all meetings of the council, that may give rise to this idea of whether or not the mayor gets to go into every executive session. It could be clarified in your work. And I made a suggestion as to maybe how to clarify that. So I'm glad to offer that suggestion if you want, but that's up to you.
Well, please explain it, because it's pretty straightforward.
It's not in this.
So my thought would be that, you could, right now you've got a section, I think 4.5. I'm not sure it's numbered yet, but I think it would be section 4.5, legislative powers. I don't know, Lee, if you could bring that up. It's Article 4, Section 5, I think, whether there is this version. Maybe it's been renumbered, maybe not.
And that's the right one.
You have the second, yeah, okay, great. Just get there. Yeah, that's it. So in that first sentence, I suggested amending that first sentence of 4.5 to read, the mayor may introduce ordinances and resolutions in the council and may participate in all meetings of council, comma, including executive sessions on the invitation of council.
Oh, good typing.
Or of the council, I guess it's not, I think we've been calling it the council, if I'm not mistaken. But shall have no vote in meetings. I think therein doesn't really work anymore. If you had the language I suggested.
Right.
That's a little
Just put,
wonky, but
No,
In
you're,
meetings.
Joe, take the therein off and put in meetings.
in executive sessions, city council can't vote.
I have no idea.
They can only discuss.
After no
So
vote,
that's
put
why-
in meetings.
no vote in meetings.
Get rid of that.
Just replace therein.
In meetings?
Yeah.
Yeah, I
Take out
wrote in meetings, you could probably just eliminate all of it, eliminate therein and be done with it. But that was my suggestion. It maybe helps resolve that question in the event there is a question.
I just wanna note that one of Tony Kuda's requests of us was that council have the right to have executive session meetings, particularly related to personnel selection, where the mayor would not have the right to attend. So it's also showing up when we look at the things that our leaders have asked us to do.
So, question I have is why we just don't get rid of participate in all meetings of the council?
Well, I think it's appropriate for the mayor to participate in meetings of council.
But I'm just saying, like, from a charter standpoint, if it says they can introduce legislation and ordinances, cool, and then a smart working together council would say, yeah, come on. And an adversarial would say no, but it would just be
Well-
figured out.
I think it's important for him to have the right to be at council meetings. I think that's normal. I think that's if you look at the other charters that we've been using as our reference points, the mayor always has the right to participate in city council meetings. You know, the general, I'm talking about general meetings, not necessarily executive session. But, so I think it's totally appropriate to say that he may participate in the meetings, but doesn't have a vote. You know, he has his veto rights, but that's sort of a separate matter.
Cause my thing with including executive sessions on the invitation, is that normally implied? Like, when you go to executive session, they invite maybe the attorney or a real estate, but like depending on what they're discussing, that's what they invite. So are we just doing this because of current business?
No, I think it's a good thing to clarify because in my mind, it goes to the separation of powers issues. So I think the argument that Council President Kuda was making is that in some instances, and I agree with Kevin that I don't know that they would come up all that often, but in some instances, if council, for instance, is discussing an appointment that council has the right to make, that it isn't really appropriate for the mayor to be in the room because it's purely a council function and he doesn't have, he doesn't have a role in that discussion or that decision.
So what would regulate that?
What do you mean?
Well, I directly experienced him being involved in something that was exclusively a council function.
But my understanding that's
In an
the current.
executive session?
That wasn't an executive
Oh, so
session.
you know that, yeah.
It wasn't an executive session, so I don't think that's broad enough.
Well, what's your example?
In the interviews for city council last time, the city council appointment, I walked into my interview and there was the mayor with city council. Or he walked in after I walked in. I think they were as shocked as I was. It was inappropriate for him to be there. It was a city council appointment.
But it was a public meeting or an executive
No,
session?
it was not a public meeting.
Well, that's my point. That would be an executive session.
Was the-
Interviews of city council candidates are not executive sessions. I would,
Well, that's what I said, wasn't a public meeting.
anything that's not a public
public.
meeting is an executive
So
session.
vice
There are
versa.
limited categories of things that may be discussed in executive session. So personnel decisions and appointments, as I understand it, is that right, Lee?
Yes.
Could be discussed in executive session. They can't take a vote, but they can discuss them.
Well, okay, so this executive session wasn't in the middle of a city council meeting,
No, it
like
It doesn't
was-
have to be.
was just described, what the definition of an executive session was just described as something that takes place inside a city council meeting. This was
I
not
don't think
that.
it's necessarily within a
Sorry.
city council meeting.
Sorry,
Okay.
let me clarify. No executive session may be entered into without opening a public meeting first and moving to adjourn into executive.
Well, that did not happen in.
So I recognize that there may not be some other business
They may have already
going on
done that
besides
before.
the executive session.
They may not have.
Yeah,
I'm not suggesting these are
don't think
regular
they
council meetings, but technically
They did.
there's no such thing as an executive session without it being within an already occurring public meeting.
Thank you for that
The
clarification.
interviews
So what
for
may
city
happen
council
is,
candidates were not public.
but what may happen is they
Sounds like they were.
may declare a special meeting and announce that it's gonna include an executive session to consider appointments to
Well, they
city
better
council.
change their practice then, because they didn't.
Well, I don't know whether or not they did it in that case, but
Well, and if there's a quorum of them there, it has to be a public meeting.
yes.
If it's not a quorum of them,
it had,
As Kevin said, you have to be in a public meeting in order to declare entering into an executive session, and then you have to come out of it into the public meeting. You cannot have a standalone executive session, and to go into one, you have to have very specific criteria for that. You can't just say, we want to go into executive session, you have to say, and you have to specify, we're going into executive session for these reasons. At least that was Oregon law, I don't know about Ohio law.
I think it is true here because I know when I've been in committee, the whole meeting is occasionally, they will adjourn to an executive session and somebody on council reads what's clearly legalese. This is why we're going into executive session.
what Harriet mentioned, I think is interesting is by this saying participate in all meetings of the council, is the council mean a quorum of the council?
Yes.
Okay, so then it has to be some type of public whatever. If it's one or two council people conducting business of a legislative nature, this is not giving the mayor authority to show up.
Correct.
That I appreciate the clarity. Now, whether or not they do or don't, that's a whole nother matter.
And Kevin, I'm curious, if we add that language on the invitation of the council, are there any current constraints on council for limiting their exclusion of the mayor? Or will it just be, some of us just don't like the mayor, we don't want him having around? I'm concerned about making sure that the council has some guidance on why you might or might not wish to invite the mayor.
The only, there is a statutory constraint against going into executive session for a discussion of discipline of an elected official. I don't want to get too far into the weeds, but you can't go into executive session to discuss the discipline of an elected official. So let's use a recent example. The Mayor Horowitz wasn't for Beechwood, who was under investigation for some wrongdoing, alleged wrongdoing, I think related to female employees, something like that. And so City Council technically would not have been permitted to go into executive session to consider censuring the mayor or finding a way to try to discipline him if there's a provision on disciplining him under the revised code, because he's elected. He was an elected official. But City Council, if that same allegation were brought against, let's say, a director, an unelected director of Beechwood, City Council could go into executive session to consider the discipline of an unelected official or employee. That's the only constraint I know of where the City Council wouldn't even be able to go into executive session without the mayor being present, because they really wouldn't even be permitted to enter an executive session under that circumstance. But every other circumstance, they are permitted to invite whomever they wish to invite into executive session. And ordinarily, the motion, when it's made to adjourn into executive session, includes a list of those people invited into executive session. And in lots of the cities I've been involved in, that list includes the mayor, almost always. I mean, in fact, invariably it's been the mayor and directors and whoever else is relevant to the conversation. Harriet in the case of her interview.
Thank you.
Yeah, but that's it. There's no other, I mean, so I don't see any legal peril to changing the charter in the way that we suggest. I only suggest it because if mayors acting under another charter provision believe they may enter all executive sessions, and City Council doesn't like that, City Council may wish to include that in the charter to reinforce the idea that when you're in an executive session and you're not a member of council, you're there by invitation.
Thanks, Kevin. I do understand that. I'm just worried about certain councils abusing that due to antagonism with the mayor. But I also agree with Guy that we do need to address Tony Kuta's concern about this. So if this seems safe to everybody, I'm worried about it being abused, but that's just me.
I would just say in response to that, they have, under the revised code right now, all the authority to abuse their right to invite people or not. The revised code gives them plenary authority as to who they invite into the room.
All right.
Well,
So-
mayors do
It's
too.
that, it's the competing provision in your charter which creates a little haze. And your charter says that the mayor can participate in all meetings of council, which I agree it's a good provision. It's important that the mayor be able to do that. But executive session,
All right.
I can understand why a city council would want to make sure that their rights to go into executive session and invite who they want to invite would be upheld.
See, and what gives me a little security about that is also they can't take action in an executive, so they're coming back out to a public
Right.
of which the mayor would be there. So if they did something harmful that should have included them, then it would at the very least be out in the meeting because the idea was, oh, you're doing X, why wasn't I included? And at least it's a public discussion.
Yeah.
And so it would only be to their detriment, especially if they, are gonna need staff to do something. So that's where I take a little comfort.
Yeah, and for clarity, you cannot have a vote in executive session, you have to come back out to public meeting. So Guy, thanks for bringing up Tony Kuda's concern about this. If this seems okay to you, I think this is a good middle ground.
Can we pass this by consensus? Are we motioning?
Let's do a motion.
Motion to approve the amendment as written.
Second? I'll second it.
Second.
Any further discussion?
This is silly and pedantic, and I'm almost apologize for bringing it up, but could we just have it say, but shall have no vote, and not just have it say in meetings, just because, I don't know, it seems just like a little.
Yeah, I appreciate that, because I was gonna do the same thing. I just didn't have the guts to come out and say it.
Just because it's like in meetings is kind of already assumed. I don't know. Just
Well, my question would be for Kevin, why did you add in meetings?
Take the place that they're in.
I was, it's just because I was worried about the word therein.
Yeah.
I didn't want to suggest that votes could be taken in executive session, since I added the executive session language. I think actually this suggestion to remove that altogether is a better one than how I drafted it. It does the same thing, but it's better drafted.
I will take that as a friendly amendment. So now we'll take this language as written.
So I think we have to vote on your amendment,
Do we?
yeah? And then we could vote on it as
Why don't we just
amended
vote
by
as
you. You wanna make a motion for that?
yes. I'd just motion to amend it so written to remove the in meetings.
Second?
A second.
Any further discussion? All in favor? Aye. Any opposed? Okay, thank you. Okay, item 16, signature requirements. I think we've talked about this already, and we've already talked about fixing this language throughout the charter, so I don't know that it needs any further discussion today, unless somebody has a question about it.
I can't remember, did we finish up all of our work around this, or are we gonna come back to that?
It's on the agenda today, the initiative referendum call.
Was it? Okay,
It is.
cool. I would like to talk about it then as one
Okay.
package. I don't know if anyone has any other feelings.
Can we move on to 17?
Please.
Okay, so this has to do with particular language that's in, again, the removal recall. So I would suggest we put this aside until we get to the language that Guy's gonna present.
I have a question. I was prepared to move the adoption of that, the last sentence there, the recommendation. But is that premature then? The stuff in parentheses, very simple.
Yeah, I think we should just go on to
Right.
put it in the discussion we're gonna have later anyway, if that's okay with you? Anybody have a concern about that? Okay. 18, this relates to language that's in 8.4. So again, I would put that aside till we get to our discussion about that later today.
And just for my reference, 8, is that all around the voter recall?
It's recall referendum
Okay.
initiative stuff.
Just double check.
19 is related to initiative petitions and how people handle making changes. We parked this when we initially reviewed the language proposed by the 2019 folks because they had suggested some changes. But again, I would suggest that we put this in this same bucket and talk about these all together. I think it'll make more sense when we do it that way.
Because are initiative petitions the same thing as referendums?
Initiative is something like a ballot initiative.
Yeah. I thought that was a referendum.
Referendum is when something's been passed and the voters want to force council to take it back.
Thank you.
So the next one has to do with how quickly somebody has to submit a referendum petition. And I guess my only question about this, which I'd like to put on the table before Kevin leaves us, is some of the sample charter sections that we included in his table have a 30-day time period and some have a 40-day time period. My understanding is that under Ohio law, an ordinance that is passed and signed goes into effect within 30 days. And so I'm wondering if there's pros and cons about having a referendum deadline that is 30 days versus 40 days. If it's a 30-day lapse before it goes into effect, and somebody has to file a referendum petition within 30 days, does the filing of the referendum petition essentially put a hold on that new ordinance pending the resolution of the referendum?
What she said.
Questions?
There is.
Lynn, is that for me? I'm sorry.
It could be for you or Lee, whoever wants to weigh in.
Check.
You want me to say it again?
Well, no. So I think there are two questions there. The first one is why 30 versus 40 or why 40 versus 30? I think that's largely the result of when charters make routine legislation effective that's not passed on an emergency basis. In Lakewood, it happened to be 40 days rather than 30.
Okay,
In Cleveland Heights, it's probably 30. In Cleveland Heights, Beechwood 30. That's my suggestion. I wouldn't imagine why legislation ought to pass. A referendum deadline would be longer than the time period within which the issue must wait before it goes into effect.
okay.
So, I think that's just largely what charter says about when legislation becomes effective. That's the first question. The second question is, does the filing of a referendum petition stay the legislation? And the answer really is it depends. It depends, number one, on what the charter says about that. So if the charter says that the filing of a referendum petition stays legislation to the extent it has not yet been acted on and can be stayed, then that's maybe what some charter provisions say, and I think that's what Lakewood says. If city council has passed something on an emergency basis, which means it goes into effect right on the mayor's signature.
Well, that typically doesn't
And
apply to a referendum, does it? If don't
Go ahead,
referendums,
Sorry, go ahead.
referendums typically don't apply for emergency measures, right?
Not ordinarily. That's typically, the reason that legislation is passed on by an emergency is it, there's some overarching reason why a contract needs to be executed and begun right away. An emergency road repair or sewer
Right.
repair or something like that.
But I think,
And so you wouldn't want, your charter wouldn't want a group of electors to try to put a halt to something that's already underway or.
but Kevin, I think in our city, there would be, there's a lot of people who think that this emergency declaration has been abused.
That's our next topic for
Yeah, we're
discussion.
not on the emergency.
Okay,
Kevin, I'm looking at
Go ahead.
I'm looking at the 2019 proposal, I think this is 2019, that says if people get in a petition within 30 days of the passing kind of thing, then that passage shall not go into effect. I'm summarizing here because it's kind of a long passage there, but it looks like if people are able to get enough signatures and turn into the council before that 30 days has elapsed, then the legislation is on hold. That's what I'm reading, that shall not go into effect.
Yeah, and I'm not sure, is there additional language there? I'm sorry, Lee, what's the section you're
It is
8.2.
Or 8.2.
subsection
Thank you.
B, I think.
but it's actually the 2019 revision.
And this is the 2019 version,
on? Right.
section
And then I also have the screen pulled up if you want, Kevin. In case you don't have the red line or whatever it is we're looking at.
No, I'm looking at what you're looking at as
Oh,
well.
perfect.
I just, I happen to have a paper copy. I guess what I was trying to figure out is, what is that Charter Commission's view on emergency legislation?
So
This- This isn't about emergency legislation, this is about the timeline on referendum petitions and their effect.
No, I understand, but that time, that the effectiveness of referendum might hinge on whether the legislation was passed by emergency. That's why I asked that. I was checking to see if referendum petitions are available to the citizens of Cleveland Heights on legislation that's passed by emergency.
It is
Whether you
not.
indicate they're not.
Yeah.
And I think, let's see. Okay, so this would be subsection C, E, Lee.
Oops. Did I hit button?
Let's see.
Referendum.
I think the one that says E, I'm
There's
looking at the
no
same one as
E.
you. No,
Is there an E,
Yeah.
B, B,
Yeah,
C?
keep going.
There we go.
Yeah.
There you go, there you
Referendum.
go.
Cool,
So
thank
we
you.
were in a different section.
Yes.
Right, but I'm trying to answer this question. Appropriations ordinances, street improvements, where they've been petitioned by residents, and emergency ordinances or other measures shall not be subject to referendum. So, I think then, in that case, Linda, that answers your question. There's no, those deadlines, 30 days or 40 days, have to do with the time period within which regular, non-emergency legislation goes into effect.
Okay. So with that information, let me again suggest that we put this in the bucket of things we're gonna talk about when we get to these changes, if that's okay with everybody?
I want to be clear that we were looking at that section that Jonathan had before we went to this next section.
Right.
Yeah, so this is what we're considering, okay. And we're somehow flagging this to know that this is what we're referring to when we come back to it?
Yeah.
Okay.
Well, it's like eight point, and then all the stuff.
It's real, basically all of it.
Yeah, all of it, but 8.2 is the specific stuff. Okay.
So 21 is the emergency measures language. So I think Lee, you may have made some comments about this in one of our prior meetings. But I think, I understand your point, Harriet. I think there have been people who have spoken at city council meetings who have some frustration about the use of emergency measures and questioning whether what council is doing as a quote emergency measure is truly an emergency. But I think this is one of those things, and Kevin and Lee can weigh in on this, but I think in the world of municipal law, the term emergency measure is what we call a term of art, and it's got a lot of meaning that comes along with that concept. It's very well understood in the context of municipal law. I think we do have some features already in place in Cleveland Heights to constrain the use of emergency ordinances. It has to be passed by 5 votes, and there are some other requirements that have to be met when something is being proposed as an emergency ordinance. So I don't have a problem with keeping the emergency measure language because of that context. But if any of you have questions or comments about it, please speak up.
Well, I said earlier, I mean, it's abused. You know, you go to, I don't go to every city council meeting, but the ones I do go to, it seems like more than half of all ordinances are passed in an emergency. And it's like, sometimes I remember, you know, sometimes they're declaring some month, you know, tulip month or something, and we're in the month, so they're rushing it through, cause, but that's poor timing, that's something they, it seems like they're rushing through things often because they didn't think of them in time. And I just, I think it's, the abuse is widespread of these emergency, and it makes it more difficult for a referendum, if you pass something on an emergency basis. So I just think that the council needs to be better disciplined and be, I think it belongs in the charter because it's clearly abused.
So I have a question in regards to that. And Lee or Kevin, if a member of the public did feel it was being abused, what's the remedy?
So it's mentioned in this document that the Supreme Court says that the remedy for this would be to take electoral action.
Yes.
Like defeat him the next time in 4 years.
Yes.
Oh, that's a good.
But that's it. They don't have the ability to file suit or anything to
No.
Nope.
undo.
No.
I have a question, please. In my mind, there's a difference between abuse and what I see happening today for the most part. And that is that when I did look at the agenda for one of the meetings, there were several emergency measures. They were basically because they had to get appropriations of money to buy things that had to be purchased immediately. It had to be done right away, all right? And that may indicate that that may indicate that there might be a better way for council to manage its time, but I don't see that as an abuse, really. I don't see that as an abuse. I see that as they should be encouraged to do a better job of planning their agendas and their spending and all the rest of it, but there's nothing we can do about that at the level of the charter. If it was abusive, it would be something where someone's slipping in an emergency ordinance to avoid the possibility of a referendum. That to me would be a blatant abuse. All right, but I'm not familiar with that kind of thing happening. So I'm less concerned about, well, first of all, I'm less concerned about this whole emergency issue. It's just.
Well, I guess my concern would be that it makes things referendum proof.
But it does take a vote of 5 to do it by emergency measures through as it does say council can make changes to this procedure through ordinance. Now, the council has been discussing process stuff. I've lost track of where that discussion is, where it was brought up about how they are to do things, civility, all that kind of thing. I don't know if any of that has dealt with use or overuse of emergency measures. Has anybody been tracking that?
I can't answer that specifically. I agree with you that they're working on it, but I do think, Harriet, I think for some of the things that you noted, which, and I've been in meetings where these things come up as well, some of them are, resolutions declaring it this or that month.
Yes.
It's not really something that, what would a referendum do? You don't want them to declare, so it's.
I hate tulips.
It's a convenience kind of thing, because probably somebody came to council and said, hey, did you know that it's tree month? Shouldn't we have a resolution supporting trees?
Why can't they just say no? But I'm sorry, go ahead.
So it's not harmful, but I think that they do have this process where they do have to have a supermajority vote, and I think they do, every time they use it, they do have an explanation of why they're doing it and why it has to be done without a longer period for consideration. But it is truly, in many cases, it is a planning issue. But I can't personally say, is it something to criticize if they didn't have a longer runway on something? Maybe something has arisen that requires a repair and they didn't know 60 days ago that it was gonna need a repair, and do we want them to wait 60 days to fix something? I don't think so. But, you're kind of trusting their judgment.
I also think that I feel like there's not really any language that we could put in, like, kind of relating to this that goes further than what like the Ohio Revised Code and stuff are saying based on the paragraph in this response. Because in this response it's talking about how like it does say that for the ordinance to be emergency, it has to be for the preservation of public peace, health, and safety, right? And so like, you know, if people are passing the month resolutions, all right, I would say that's not necessarily for that, but, you know, I mean,
Public
there's
peace.
nothing else we can do.
And
No
you
harm, no
ever
foul.
made a tulip mad?
Yeah. So, I don't know.
Not the deer had eaten all the tulips in Cleveland Heights.
Yeah, we don't have,
Well, the legal advice is not to mess with it because it's not something we can control. And this in part is really a public relations issue. The council and the mayor have not been clear about why so many things come up as emergency measures. So that's something that when President Kuda is doing one of his community outreach tours, he might, you know, bring that up from trying to explain it rather than trying to complain about it kind of a thing. It is, unfortunately, it is the public education. It's like, as Harriet says, why are there so many of these things emergency measures when I don't see the building on fire or the deer eating the tulips kind of thing? But that's what we're at here.
well, I just wanted to make that point because, you know, again, it seems to be it seems to be a problem in need of solution, but perhaps it's not.
It's
It
partly.
is, just maybe not here, sorry.
That's okay. It's partly the word emergency, but again, this explanation makes clear that that's the word that's used and trying to mess with that word is gonna be a problem. So we wouldn't consider it an emergency, but that's the term of art, isn't it?
Well, the only reason to put it in the charter is if council's the problem, they're not gonna if this is their practice, they obviously like their practice, and so, you know.
But the next council may not, and so you don't wanna tie hands too, or run into all these other.
I'm just making the points, should be made.
Any further discussion on that? Okay, so we're on to 22. I think this has to do again with the language, and I'm not sure where this comes up. I don't know if this comes up in 8.3.
It's in a lot of different
Yeah.
places.
But I think that there's a suggestion here that we use specific language, which I would categorize in the updating language bucket. And we
Or
can,
isn't it really proper legal language? Okay, well, I guess it's the same.
well, I think it's
The official canvas is, I think that's changing that would be just an update. It's not,
yeah,
it's just old stuff, like saying electors rather than voters kind of thing. Where it does say revised to certification of the official election results, that seems nice and clear and terse.
Let's just do that, do the suggestion.
It says it's used by the Cuyahoga County Board of Elections, the Ohio Secretary of State.
yeah. I think it makes sense to make that change wherever we need to in the charter, and we can figure out
Yeah, right now it
by
looks like
word
there's.
search where we need to do it.
Yeah, there's two places where it's got that phrase, official canvas of that, you know.
Where did you find it?
8.3 under recall,
Okay,
and in 13.2 effective date.
okay, thank you.
And I'm just saying that explicit.
Using the search function really helps, doesn't it?
Mhm.
Especially when it's a weird word like canvas with two S's.
This is why paper is not as nice.
Okay,
It's like,
do we have a motion?
So moved.
Second?
Second.
Any further discussion?
So basically, we're changing certification of the official canvas to certification of the official election results.
Yes.
Yes.
Do we wanna change that title of Canvas?
No, this is just results of canvas, like, it's not that phrase. Official canvas?
But in the heading where it says canvas of votes, maybe we should say certification.
Yeah.
Instead of canvas.
Cool.
Yeah,
Friendly amendment.
certified.
Friendly amendment accepted.
And would we cut the results, we would cut canvassed and in that first line?
All elections shall be conducted and the results certified by the election authorities.
Well, no, it has in here this revised to quote, certification of the official election results.
I know, but that's in a different context.
Yeah, we wouldn't have to add anything, Jonathan, I think we just
We're
cut.
just taking out canvas and.
I could, instead maybe try to identify the places that can be changed.
Yeah, let's do that.
Cool.
So let's, let me make a motion that we,
We haven't voted on my motion yet.
I know, but it's been changed. So let me make a motion that we, empower Lee to do a search through the document and recommend to us where we need to make adjustments to reflect the use of the language used by the Board of Elections and the Secretary of State, which is the certification of the official election results. Does that make
Second.
sense?
So why was my motion changed?
Because it isn't just a matter of using that language, it's other changes that have to be made throughout the document.
Robert's rules, but I'm fine with it, I just.
Any protest from Lee?
I mean,
We volunteered to do it.
oh, for that?
You're okay with this?
Oh, yeah,
All right,
that's fine, but.
That'll be easier because.
Would you want us to go back and vote on yours and then
No.
vote on yours? All right, so I made a motion, do I have a second?
Second.
Any further discussion? All in favor?
Aye.
Okay. Okay, 23. Do other city charters limit removal in the first 180 days?
So can we just deal with that when we get to the initiative referendum removal recall?
That's okay with me.
Okay,
Then 24, 25, we've already talked about and resolved. So 24 and 25, Kevin did his presentation, so unless anybody has questions about that, we don't need to discuss those any further. Any questions on those?
Well, they're not gonna go in either, these are not gonna go in the charter anyway, right?
Correct. These were just questions that we posed pretty early on. Okay, then 26 relates to the revised code section. We talked about that in the context of the changes we agreed to in Article 3, so we don't need to talk about that any further unless anybody has a question. 27 has to do with the suggestion we had from the mayor about city council having subpoena power. So what we know from this chart is that the Ohio Revised Code provides the city council can do that. I personally don't see a reason to put it in the charter, but what do you all think about that?
I don't see a reason to put it in the charter, and in fact, I don't know why, no, I don't.
in the interest of simplicity, if it's already dealt with by the revised code, I would not want to add that to the charter, but
Yeah.
it's just my attitude.
I would go the other way because from where I'm from, it's anomalous for a city actually to have subpoena power. They would have to go to a court for a subpoena to be issued. So I would like that. It doesn't have to be, fanfare or anything like that, but I would like it added so that, anybody reading the charter will know that the city actually does, by, state authority kind of thing, does have subpoena power. And I don't know if how that would be executed, if the city would then contact the police department or have some, that kind of thing. But the clarification, I think, is helpful because to me, in both Massachusetts and Oregon, cities did not ordinarily have subpoena power. They had to go to the courts for that.
Can I ask for a clarification by the attorney people? Doesn't a subpoena get issued by the court, period? And a city council, or can city council issue a subpoena?
I haven't looked at that in the context of city council. I mean, all my subpoenas go through a court, but,
I thought it was a power that the court had. I didn't know that just
I
anybody.
suppose it can
I'm
be
sorry?
empowered.
I think you're right. I don't know about locally.
I've seen, sorry.
No, please speak.
Please. Yeah, go ahead, Kevin.
Yeah, thank you. In some codes, criminal codes, there's a specific criminal prohibition against ignoring the city council subpoena. Probably be like a minor misdemeanor or something like that. So that would be the enforcement. I don't think it would be it wouldn't be enforced in like a civil matter by a judge. It would be enforced as a criminal prosecution against someone who ignored a council subpoena.
But does the council Would they have to go to a court to have a subpoena issued, or do they just issue it themselves? That's our question.
They can issue it to
They would just issue it.
Okay, that's clarification, thank you.
Yeah. So
Under
to
the
me,
revised
again,
code.
that is reason for putting this in, because most people would assume that you'd have to go to a court to get a subpoena, but the city apparently has its own power.
I guess I don't see any reason to put it in the charter if it's provided by the Ohio Revised Code. It applies anyway.
Would this be something that would be noted if we're gonna do any kind of recommendations concerning training of council members?
Well, we could, you know, and certainly in our report, we could note that it's already provided for in Ohio Revised Code.
Yeah, it says when a municipal charter is silent on a subject and it is not in conflict with the, you know, the provisions of the revised code apply. So, yeah, I agree with Linda. I don't know why we would.
Well, again, he brought a list of concerns brought up both by Tony Kuda and Mayor Sarin kind of thing, and this is one of Mayor Sarin's concerns. This is apparently clarified, if not actually written into the charter. Finding that the council already does possess that power, we should at least address it in the report as one of the mayor's concerns.
Yeah, we should put it in the
But
report.
I think we can address it in the report and say that we felt it wasn't needed in the charter because it's already in the ordinances. So we didn't, you know, we didn't forget about it.
Yeah, no, that's a good point.
I don't know that we need to take action on it. Do we wanna take a vote on this?
Does that make sense to you, Kevin?
I think we should take a vote.
You wanna make a motion?
Sorry.
Okay,
Yeah,
Oh, wait.
all right.
no, go ahead.
Go ahead, Kevin.
I'm not sure the question. Does what make sense? That you vote to leave it out of the charter because it's already provided for in the revised code?
Correct.
Yeah.
Personally, I think that makes sense because I've never heard of a city council issuing a subpoena, which means it's so rarely used that it probably doesn't need to be a part of your charter. That's my only thinking.
Oh,
You
so,
wanna make a motion, Jonathan?
yeah, I was gonna make a motion to include subpoena power in the charter.
Second.
Any further discussion?
And he's making that because we can't make a negative motion essentially.
Correct.
All in favor?
Oh, wait, I'm sorry, so what is we're proposing that we note subpoena power of the council in the charter revisions that we're proposing, is that right?
Yes.
His motion is that we add subpoena power for city council in the charter. Okay.
I feel like it wouldn't hurt to have it in there, especially just because there seems to be confusion about it. And it's like, I mean, if it's never used, it's never used, but it is a kind of a significant power to be wielded by council. I think it could be in there. It wouldn't hurt.
One thing it does is say to the mayor, we read your request, okay?
Right, we'll do that in the report.
We can do that in the report too.
Yeah. All right, any further discussion? All right, who's in favor?
Aye.
Aye.
Okay.
Oh, wait a second. This is to put it in the
Put it
charter.
in the charter.
I changed my mind. I'm gonna put it in the charter. I've been convinced by these worthy people.
Okay, who's opposed? All right, so we have 3, 4, and 3 against.
No, four.
4-4. Yes,
I think
Roland voted
also
for.
voted for.
Yes.
And you voted,
No,
Okay, so
Andrew,
Graham,
Andrew
yeah.
Roland.
what was the vote then, please clarify?
4 to
3.
3.
And the 4 is in favor?
And 4 is in favor.
Shocker. Stunning upset.
Okay,
Toss it to Lee too.
What it will be and where it goes next.
all right, that's the end of the chart. Okay, let's pause for a minute. I don't think we need Kevin for anything else. Does anyone have a thought of something else we need to have Kevin's time for?
no, I trust your judgment.
Linda, you asked me just to be ready to talk if necessary on I think the mayor had made a couple of requests.
Oh, yeah, let's look at that list. Yeah, thank you. Let's look at that list real quick.
Appoint all board and commission members.
Yeah, we've already talked about a number of the things on that list, but let me get to
I
that.
don't think we have that list.
No.
It is.
Yeah, we do.
It's in here.
It
It's
was
the-
in, it was in we were given.
Was it?
Yeah,
Okay.
I mean, there's
It
a
looks
very
like
brief
this.
version of it. This is the
Oh,
brief version.
okay.
I also printed off the actual submissions from the
It's a
mayor and
one-page
Tony.
right
Could have
before
really easy. Look at that, I can read what's in it.
I must have lost
What
this.
about the other council?
There's one page, that's why.
Were there no suggestions from other council members besides?
If you don't, it's always fine.
I don't know, Keith.
Well, yours truly did not track it.
You know, we could go back and look, but.
These came in
Yeah,
specific.
I thought Davida had.
Damn,
Well, she,
there we go.
See, having
You
fingernails
can go back,
helps.
you wanna go back and look at that?
All right, thank you.
It was, I could see
You
it
just have
on
to
the.
look at minutes. You could look at her comments.
well, Davita's submission to the council is extensive with many requests. Okay, by my recall. And yeah, so if you want to, it's there on Dropbox, Davita's submission.
So to maximize our use of Kevin, do we wanna hit some points or just go through this piece by
Well, let me note the ones that I think we've already covered and then see if you all agree with that and if not, we can pass on it. So we've already dealt with 1, we dealt with 3 just now. We're looking today at 4. We could talk about item 5, although I think we may, and we haven't talked about that yet. We don't need 6 because we're not doing that. We've looked at the departmental responsibilities. We have not discussed 8 and we just talked about 9. And in the council president's list, we have already addressed 1, 2, 3, 4, 5. We don't need 6 anymore. We haven't gotten to 7. We've just talked about 8. We haven't talked about 9. And I think we've already talked about 10.
When you say talked about, that doesn't mean decided.
I think we have decided on all those
Decided all
things.
those things?
Yeah,
1 through 5, and then what else?
1 through 5, we don't need 6, and we've already discussed 8 and 10. So we go back up to the mayor's list, and item 2 is explicit investigatory power for the mayor.
So I guess really quick, does anyone disagree with what?
Yeah, does
the thing
anybody
we
disagree?
didn't touch?
I don't know, cause I missed a meeting. I don't disagree, but
Well, and you know what, I viewing it is that it was tucked in some different places, so at the very least, like looking back through things, if for some reason anything feels omitted or needs to be strengthened, if we can always bring it back up, like it's not a final call, at least that's my impression.
Yeah, I think it's just that these things came in back in February, the beginning of February, and we have since made decisions on a number of different provisions that address these issues. But we haven't talked about item 2 under the mayor's list.
Yeah. And that wouldn't have existed in the 2017-19, and we don't have language around it, right?
No, and I don't know that, I would be interested in what Kevin and Lee think about that. I mean, I don't think the mayor needs specific investigatory power. He's already got the power to basically run the departments and deal with his administrative staff. So if he's got a problem with a director or another employee who's not performing appropriately, he's got the tools to deal with that.
if by implication this means he could investigate members of council, I would strongly object to that. And I think that's what he must be getting at here, since he has complete control over
Can
everybody.
I just read what he submitted? What he did is refer to the Charter of Lakewood and their section 3.7, very brief. The mayor or anyone appointed by the mayor may, without notice, cause the affairs of any department or the conduct of any officer or employee to be examined and investigated.
Is an officer an elected person?
Yeah, but
Yes,
he says, oh, that's right, that would
So it would
include,
include council, right? I think officer would be council members.
that's not separation of power.
So Lee, Kevin? You guys wanna argue over who goes first?
Jonathan, don't make any suggestions.
Number 1, 2.
Go ahead, Lee, if you'd like to start.
I don't know that I have anything right now.
I'm not so certain that officer in that instance means elected member of another branch of government. I think officer there means someone who's in the employment of the mayor.
I think isn't officer, under the Ohio Revised Code, is a defined term that includes elected officials?
Maybe, I'm not sure that that's what that means though in Lakewood.
That was
I
right.
don't think it's defined, it's not necessarily defined in Lakewood's charter, but I'm fairly certain that provision is not meant to give the mayor investigatory power over a council member. I think, in fact, that to me is, I mean, there are other ways to investigate, let's say criminal wrongdoing, right? You can refer a matter to the police or the ethics commission or the elections commission.
Sure.
And let them, or appoint a special prosecutor to investigate. But if a mayor is given the authority to investigate someone who could be viewed as a political rival from another branch of government, I think that's problematic. And vice versa, if council is given the authority, I think you've already nipped this in the bud with your other separation of powers, balance of powers provisions. But if council were given the authority, for example, to consistently subpoena the mayor or subpoena the mayor's directors, that could also prove problematic. And in fact, what we would probably have is some version of what's happening in
East Cleveland,
Jordan's committee, something like that.
which we don't want.
Guy, if we took out officer and put in employee, would you read the sentence that way to make sure it's not redundant?
All right, so the mayor or anyone appointed by the mayor may without notice, cause the affairs of any department or the conduct of any employee to be examined or investigated. That drops the 3 words of any officer.
Yes.
Okay, so it just takes the reference to the officer out of what Lakewood has in their section 3.7. But can I,
How are commissions treated?
Good question.
I think that's why the offices were.
I would imagine it would be, because we're officers of the city now, right? Because we're commissions, right? I understand that.
Because they're commissioners too. Planning commission.
Yeah, but I think
It's just-
officers
it
is
isn't
gonna
really necessary
include,
to have this.
yeah, it is not necessary.
Well, that was my next question, but yeah.
No, I just want to offer, I don't see what it adds. I don't see that the mayor already doesn't have that power.
Is he asking that to be investigating his own employees?
Yeah, which doesn't make
But
sense.
he's-
Well, or us,
Or what he's,
or, there's a lot of fraud commissions right now in the city.
What
You know,
kind of commissions?
fraud.
Fraud, I thought you said
Well-
fraud.
Just like, okay, this is a different meeting all of a
The Environmental
sudden.
Transportation Committee has had a hell of a time. Yeah,
I've just looked up officer or employee in the Ohio Revised Code, and it says that this does not include any person elected, appointed, or employed by any political subdivisions, and political subdivisions include city governments.
So it doesn't include his
it
employees.
doesn't include anybody then.
So who's he investigating?
I don't know.
And then there's another provision in the ORC in section 109, where only if you are with the state or employed by the state, then you are elected or appointed office or officer. Like, it's a different definition if you literally work for the state.
But this is in the charter somewhere,
Lakewood's, right?
Lakewood Charter.
it was Lakewood's Charter 3.7,
Yeah.
supposedly.
Interesting.
Well, they had a mayor, well, they've had mayors who've done time. What was his name? Sinestra or Sinostra or something.
Can I just,
Sinagra, yeah.
can I ask where we are on this? Are we sympathetic to giving them,
No.
doing this
I
for
don't
the
see
mayor
any
or
need for
not?
it.
If
I
not,
don't see a need
can we go on? We should just settle that we are not interested in it, so we can go on to something else.
Well, we could have, if you wanna make a motion.
I don't wanna make a motion.
I make a motion that we add mayoral investigatory power to the charter.
I'll second it.
There we go.
Discussion?
I think it's a bad idea.
Just a discussion, just a quick point of discussion. Revised code has some provisions on this. I think you were looking in Title I, state government, when you were looking for definitions. But in Title VII, which applies to municipal corporations, 733-34, for example, says the mayor shall supervise the conduct of all the officers of the municipal corporation, inquire into and examine the grounds of all reasonable complaints against any of such officers, and cause their violations or neglect of duty to be promptly punished or reported to the proper authority for correction. That's 733-34, and then 733-35 says that the mayor can have general supervision over each department and officers provided for in Title VII. Whenever the mayor has reason to believe that the head of a department or such officer has been guilty in the performance of his or her official duty of bribery, misfeasance, malfeasance, nonfeasance, misconduct, all the way through habitual drunkenness, he shall immediately file with the legislative authority, except when the removal of such head of department or officer is otherwise provided for, written charges against the person. So that's a,
Does that define
again,
officers?
say it again, please.
How does it define officers?
He's definitely right, I was looking at the state code. Not the city codes.
You are in 733. Appointment of municipal officers in cities. The Director of Public Service, Director of Public Safety, Directors of the University, Street Commission, or any officer or member of a board whose appointment is required by Title VII of the revised code shall be appointed.
I ran into the same problem. I was trying to find how they define officer and I could never get anything other than and other officers.
Well,
But short
why
of
don't
that,
we, why
I
don't we
think
decide
the
whether or not we
prior
even want it
question is,
before
do we
continuing
even
the
need
debate? Yes,
I'm sorry, too many conversations.
They said.
I was gonna say, the motion on the floor is, do we even wanna do this? Right now, we're in the weeds about a term that we may not even use.
so let's
Yeah,
vote.
so I think the
I think we
revised
should
code
vote.
contemplates that officers here are executive officers, which means they work for the executive branch, the mayor's branch. But I'll defer to you. If someone has found authority that officer includes council member, for example, I say to be corrected. But for example, if you look at 73301, executive power in cities, it says the executive power of cities shall be vested in a mayor, president of council, auditor, treasurer, director of law, director of public service, director of public safety, and such other officers and departments as are provided by Title VII. I guess president of council is considered an officer. Maybe that could be someone that the mayor could investigate.
Yeah, I thought I looked at one point in Article 7 because I was looking at something else in Article 7 and I came upon officer and I was curious as to how broad that term was. And I thought what I found is that it included elected people like city council members. But I don't have a code section to cite for you.
Trump was determined to be an officer, he claimed he wasn't.
Can we vote on the motion?
Yes.
Kevin, to get back to what you were saying about the mayor's responsibilities about, to deal with malfeasance or, habitual drunkenness and all that. So the mayor does have the responsibility, but what you read did not seem to indicate the mayor had any explicit investigatory power. Somehow the mayor was supposed to deal with these issues and submit a report or bring criminal charges, but it didn't mention any ability of the mayor to actually investigate any of those possible whatever, charges, et cetera.
I guess I view the two as one and the same.
So there's already an implicit authority for the mayor to deal with these issues in the administrative branch kind of thing. I think the mayor was asking for an explicit power here rather than the implicit one.
Yeah, so, again, I just don't see the need to put it in the charter, but does anybody have any further comments? You wanna call the question?
Call the question.
I just wanna say, I think just for me to be consistent, that the like subpoena power is kind of the same situation, right? Where like the subpoena power for council versus this investigatory power for mayor is like something implicit in the ORC, but that like we could include.
Well, I think the mayor suggested both because he wanted investigatory and he threw in the subpoena power,
As like a balance.
honestly.
Yeah.
And I don't
I
think either
honestly
one of
agree
them
with that.
is needed in the charter. I don't think we need any further stirring up of people doing investigations of people or using subpoena power. We don't need that drama. We have enough drama,
I totally agree.
but that's just my personal view.
And I agree with Graham that having put the one into the charter, it would seem even-handed to put the other into the charter.
Well,
Well.
okay, and I would say neither one of them is needed in the charter, but whatever.
Can I just make if I might, in terms of response to you, Graham, I think common understanding of an executive in a position includes you're responsible for all those people, you have the rights to ask them any, et cetera, okay?
Right.
Whereas it is not, by our experience, a common understanding that the council has a right to issue a subpoena. It's totally new to me, I've never heard of such a thing.
That does make
But I
sense.
do accept that is the case. So putting one in and not the other one, to me, is totally fine, makes sense.
Call for a question?
Oh, I'm sorry. Can I just clarify, can I ask to clarify one thing on officers?
Sure.
Sure.
Your current charter says that the mayor shall appoint, promote, I think this is your answer. The mayor shall appoint, promote, transfer, reduce, or remove all officers and employees of the city except members of council, judges, and any other person whose terms of office are fixed by this charter or law.
Which makes them
So
officers.
that does suggest that when an officer capable of being investigated by the mayor under the mayor's plenary authority to be the chief conservator of the peace and enforcement of the laws would include
City council.
other elected officials.
Yeah.
The mayor just can't remove,
Right.
appoint, promote, transfer
What section is that in?
not in his
Executive
branch of
powers.
I'm sorry?
Article 4, Section 3, executive powers, 1,
Okay,
2,
thank you.
3, 4, about the third, fourth, fifth lines.
Thanks, Drew. Okay, so, any additional comments or questions or?
Can I call for the question?
Just to
Can we actually-
clarify, that means
Can I-
that officers are city council.
Right,
All
I
city
think we
council
understand
members,
that.
not
Guy?
just, well, I just wanna make sure we do.
I just don't know where, I'm sorry, I'm a little confused. Okay,
Okay.
I'm not exactly sure where we're at. So does the council today already give the mayor the right to investigate council members? No. It does not.
No.
Okay, all right, okay,
Not explicitly.
No,
No,
Explicitly.
no, it explicitly says he can't.
cannot, okay, all right, thank you, that
No,
clarifies for
no.
me.
no, pardon me. I don't, that is not what I'm reading, what I just read.
Okay.
No, it does not say investigate, they're either for or against. It just says appoint, promote, transfer, reduce, or remove. Nothing about investigation.
That's just about how officer is used in our charter.
Yeah.
Right,
Right,
Used to
Okay.
include council members.
Okay.
so you understand the point there, Guy, that it's when it
But in
refers
next
to
sentence,
the mayor,
shall see that all laws are
Yeah.
enforced, shall be the chief conservator of the peace. Which to me suggests that the mayor has the ability to investigate any wrongdoing by any officer.
Yes. So there's an implicit authority but no explicit authority, I think we're clear on that.
I'm sorry, but like, the question is, does that officer include the elected official called the council person?
Yes.
But we're not adding language with the word
I'm just
officer,
trying to
right?
understand what it says already.
Yeah, being clear, the motion was not to add the language.
I understand. I got it.
Easier to understand.
I got it. Okay, I'm
So what's the motion?
It was just that I don't know anymore.
Yeah.
The motion was to put in the charter a specific provision giving the mayor investigatory powers.
No language.
Hmm?
No language
No
was what I
language
just.
attached, just explicit
And
investigation.
that's been seconded. All right, so we wanna vote?
You're asking Jonathan?
No, I'm asking everybody, if anybody has any more comments, questions? Okay. All those in favor of adding investigatory powers, raise your hand. Got 2. All those opposed? We've got 5. Okay. The next item here is Article 8, Section 3. This has to do with nominating petitions. So, I think this suggestion seems fine. I would suggest we put this in the bucket of things we're gonna talk about when we get to Guy's language. Because it has to do with this is Article 7, this isn't Article 8.
Oh, okay.
So this has to do with, we've got language in the charter right now that says that you can't sign more nominating petitions
Okay.
than there are candidates. So for instance, if we have 3 people running for
This is
city
number
council, I couldn't sign 4 nominating petitions. And I think the point that was made by the mayor was that we shouldn't have that prohibition because it's confusing and it makes more work for the Board of Elections. It doesn't really benefit people, et cetera. So I have no problem with that. I think, we could take that out as just being a simplification provision that's over regulation. But what do you all think?
Isn't it kind of standard practice to, across the board, to not, to tell people to not sign more petitions than there are open seats? I mean, I just think that, to me, in my whole life, that's always been the case, whatever
Yeah,
city,
I don't know, cause I haven't looked at this in any city other than Cleveland Heights.
There were more people running for the open seats on council this last election than there were open seats.
Right, that happens a lot in Cleveland.
Yeah, no, I'm saying, I'm not, to me, it's standard practice everywhere to be limited, for voters to be told by the canvasser, the petitioner, you need to only sign petitions for the number of seats. You can't sign three petitions if there's only 2 seats available. I just think it's standard practice. It just seemed like an odd thing to,
Well, if this spills over, if we're going to ranked choice voting, that could change.
yeah.
Because then you might have a larger field of candidates and you might
Yeah.
want to get more of them on the ballot. So I think I agree with Linda. I think we should eliminate this because it's infringing on democracy in the sense of how, we want to get as many of candidates you would like to vote for on that ballot as possible.
Well, Kevin and Lee, do you have any sense of whether this is common practice or not common practice?
I don't see it in the state law, so the default, unless Kevin disagrees, I don't see that it's the default position in state law. So this is a variation.
So your point is the state law kind of is the default provision.
It would be, if you eliminated this provision, it would default back to state law. Which I think was the point, so that to make it easier on the Board of Elections.
Mm-hmm.
I have a bias toward making something easy and possible to do unless there's a real good reason to impose greater burden of effort. And I don't see this brings us any good that's worth causing the Board of Elections or anybody else to be concerned about it, number 1. Okay, I just don't think it brings any benefits, so we should get rid of it. Number 2, with all due respect to you, Harriet, who's very politically motivated and aware, I don't know how many petitions I've signed, okay? If you got 15 people running for 3 seats on council and they each make a good case to me, I'll sign the petition, okay? So, I'm not keeping count. And I'm a reasonably intelligent person, you know, so that's why.
I think you're agreeing with Drew's position that it lets more people run, so.
Yeah, so I'd say go more the merrier, or whatever you wanna say, I'd say let's get rid of it.
Yeah, well, my only point was common practice, you know,
No,
if it's common practice, then you know, if it's common practice, if it is, then there must be a reason for it, but that was my only point.
We'll make a motion that we remove that section from the charter,
I'll second that.
if that's clear enough that people understanding the highlighted section.
Any further discussion?
Call the question then?
All in favor?
Aye.
Aye. Any opposed? Okay. Let's see, item 8 on the mayor's list, this is to explicitly grant power to individual members of council to introduce legislation. So what do you all think about that?
I guess, quick question, why does it have to be explicit? Cause can't anyone introduce legislation?
Well, I think this goes to city council's rules among themselves. So I think the charter gives the city council the authority to make rules that govern their meetings, et cetera. So this would really go to how city council establishes their rules. And for that reason, I don't know that I wanna micromanage that in the charter any more than I wanna micromanage, you know, how often the committees have to meet or, you know, any other details about how city council handles its own business.
It's
But that's just my perspective,
Article
so.
3, Section 8.
What is, do you have the mayor's justification for this?
I think that when he commented upon it, he was reckoning back to when he was on city council and felt that he was being stymied when he wanted to introduce legislation. But, you know, council is working through their rules and kind of procedures for how they want to use their committees. And part of it has to do with, I guess for lack of a better term, I would call like ordinary order. Like, you know, how do you advance legislation? Oftentimes legislative bodies would say, you propose something, it goes to a committee, maybe it goes to a second committee. I think we heard from one of the mayors that everything in their city goes to a committee and then it goes to their budget committee or something like that. So you have kind of a process for doing things that allows legislation to have, you know, kind of a ordinary vetting and consideration before it gets formally introduced. And I think it also, that kind of a process encourages getting other viewpoints and really developing your legislation before, you know, you kind of jump ahead 3 steps. But that's just my limited understanding. Drew may have a better understanding because he's been out of city council.
Yes, the individuals could, you know, draft something, get it put on the agenda, get it discussed, get it referred to the legal department, brought back before the city council, that kind of thing. It wasn't this kind of multi-layered into a committee here, into commission there, into committee, all that kind of thing. So it was a simpler form of government and a more direct process. It wasn't used that often, but I know that we've heard this before, some people get into the council with some legislative drafting experience under their belts and others are complete novices. And so there is that problem there that it may be those who are ready to go with it are feeling hampered by the kind of Byzantine process.
And I was thinking, this is outside of what the mayor may have said, but in the mayoral section, we did say the mayor can introduce legislation, so I don't know if it was also an attempt to balance, but you know, the mayor's an executive, so I see it being explicit about that. Given council's the legislator, I just don't get it. Like, if you can't introduce legislation, who can't, you know, it's just like that.
I know, it seems like,
Can I just read, it's not a long paragraph, can I read what he wrote? Article 3 should be amended to provide an explicit power granted to individual council members to introduce legislation. Much of the internal council difficulties I've observed have stemmed from confusion on council members' ability to introduce legislation. These difficulties are exacerbated by repeated attempts on the part of council members to restrict other members' ability to individually introduce legislation. Council acts as a body Members have virtually no individual authority. Council member, this is basically, I think, what he's offering us his proposal. Council members should be empowered to make and second motions, vote, and introduce legislation without undue restriction.
And my understanding is right now they have that power. They can do that, but it's just not explicitly granted?
Well, I think it has to do with their rules.
Okay, the
It has to do
legislative
with
process.
city council agreeing on their own rules of how they're going to advance legislation.
Uh-huh.
And that's why I'm a little bit reluctant to get into the details of how the city council decides to conduct their development of legislation.
Uh-huh.
I could just point out, I'm not certain what the confusion that the mayor refers to is with respect to introducing legislation. There may be a historical confusion over that. The codified ordinances, 111-16, says the director of law, upon the request of any member, that is to say, member of council, shall draft the form of any proposed legislation desired by such member. That most certainly to me makes explicit the idea that individual members of council can introduce legislation. And to me, it goes without saying that that is implicit in a council member's, any member of a municipal legislative body's authority to introduce legislation individually.
Can you say
I'd like to point that out, but I'm not discounting whatever the mayor's concerns are over the historic confusion, maybe, and so I leave it to you as to whether or not you want to address that. It's just, I'll tell you that I think the ordinances make it very, very clear that individual council members have the right to introduce legislation individually.
And are you looking at ordinance, the charter, ORC,
Ordinance, 111-16.
of Cleveland Heights?
Yep.
Okay. The ordinance, yeah,
oh.
yeah. That's why I was late. All right.
And are they aware of that?
Which has not changed since 1950. Looks like.
Would it,
Well, that's
But city
Would-
council needs to read the ordinance.
Would like the legislative process that council's putting in place right now supersede that ordinance? So that like if the legislative process restricts a council member's ability to individually introduce legislation, would they, I don't know, would the ordinance still allow them to do that?
I thought they'd have to repeal it, but that's just
Yeah.
lawyer.
But if you're a legislative body, it's like saying, it's more than stating the obvious. A legislative body legislates.
Right.
That's what it does.
If council makes a rule that's in conflict with an ordinance, do they have to repeal the ordinance first, or does the rule take precedent?
Rule will be under ordinance.
Yeah, but it seems to me though that we're familiar with the fact that legislative bodies typically have procedures. I mean, Congress has procedures. So it isn't surprising that a city council would have procedures about what you do to introduce legislation. And again, I think when the other mayors were visiting us, I forget which one of them commented on this, but one of them did comment on how their legislation gets developed and, goes through committees and that sort of thing. I think one of the challenges that's happened in Cleveland Heights is that there have been people who've wanted to introduce proposed legislation without having it considered in a committee setting. And part of the problem with that is that somebody may come up with the greatest idea on the planet. But, you don't necessarily, when you're developing that as a person, you may not think of all the angles that other people may bring to it and considerations that may need to be worked into it in order to develop something that you want to share with the world. So I think there has been, what I would say there's a training opportunity for the council to understand best practices in developing legislation. And that's part of what's going on here in terms of the learning process, I think. But that's from, an outside observation that may not be the best informed. I don't go to all the city council and committee of the whole meetings.
I just want to put a vote in for the idea that for us to take this step and only this step in terms of the way council does its business doesn't seem to be consistent with expecting council to put together a comprehensive means of doing their job. So I'm hesitant to say you can do whatever you want, but you have to do this, when it's something which, if it's gonna work, they should be agreeing on it as the way that it's gonna work in the council.
So were you making a motion?
No, I'm not making a motion.
Okay.
I'm expressing the fact that should a motion be made,
Got it, that's
I'm
the,
not gonna support the motion.
got it, thank you.
Somewhere, we were looking at language that involved training and orientation and that sort of thing. So I think putting something to the, especially, with special focus on council or initiated legislation, something like that, because this is obviously something that everybody needs more clarity on. So I would recommend that. Then I'd also recommend we put this issue into our report. I agree with Guy that we shouldn't micromanage in one area, not in others, but it definitely is apparently an issue, because I've also watched council meetings where somebody just off the top of the head says, well, I want to propose legislation, blah, 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 and they're just kind of freewheeling kind of thing, and it's then the city attorney has to say, anyhow, so I think mentioning this in the report and, putting it more explicitly into our training recommendations would make sense.
Okay, well, Craig is working on the training recommendations, so Craig, is he still on the screen? Yeah, Craig, you can make a note of that
Oh,
for
you're on-
your
you're on.
training recommendations.
Yeah,
Okay,
Official.
okay,
And
any,
then, Kevin, wherever you found that language in the ordinance, you might want to pass it along to Greg, because that's helpful, I think.
okay,
will do.
any further discussion on this? You wanna call the question?
What was the motion?
Yeah.
No motions.
I'll make a motion.
I thought let me look back, I thought we had a motion, but maybe.
Yeah. No.
Oh, we didn't have a motion.
Sorry, I move that we explicitly grant power to individual members of council to introduce legislation.
I'll second it.
Can I call for the question? Because we've done a lot of discussing.
Any further discussion? Okay, vote, all those in favor? Opposed?
Opposed by consensus, or defeated, or whatever.
Yes, right.
No, there's like a term, right?
Yeah.
So now we're moving along to
Number 7.
number 7.
Council.
So this
Council
has,
President number 7.
yeah, Council President number 7. So this one, we looked at the charter review section of the charter. You wanna pull that up? I think it's maybe 14 or 13.
It's like the end, right?
Yeah.
It's the one where it's like every decade.
Yeah, and we agreed on how often it should happen, and I think that section says that city council appoints the charter review commission. So I don't think we need to change anything on that.
We were appointed by the mayor, right?
Well, this council decided
Oh,
to
this is.
permit the mayor to make some of the appointments, but the
Okay.
charter
The charter.
says the city council appoints the members of the charter review commission. The council shall determine whether to appoint,
Is this
Ah,
2017, 2019?
there we go.
Isn't?
the existing charter says the council will appoint. And this language, doesn't this also say the council will appoint? It's hard for me to
The
see.
council shall, at least once during.
But Jonathan, is this the proposal of the
That's
previous commission,
2019.
or is this the?
This is
Yeah,
all new.
but I don't think it changes that point.
I mean, I have
It's all
to
new.
look at the current one.
The current charter is quite simple.
10 years, council shall, by ordinance or resolution, determine whether to appoint. That's what it says, currently.
Yeah.
This adds, it adds additional language. And dates, which I don't know why.
Could we see the rest of the language?
I think the dates were added just to clarify, when does the time period start running till the next one?
So basically, the 2019 commission replaced this entirely with this new language.
Oh, and they went from, I'm sorry, they went from consider to shall. Right now, the charter says they can or can't, they just have to consider it.
Determine whether.
Yeah, this is they shall do it every 10 years.
Compels
Yeah.
And the current charter does not say how, by what means to appoint, whether by ordinance or resolution or this or that sort of thing. So it just says determine whether to appoint. This goes much more specific. Maybe, obviously, the dates would have to be changed because we are the new charter review commission.
Well, this does presume that whatever we recommend would be voted on this year, whereas it could be next year. So that January 1, 2025 date may need to be changed, but
Could be just changed to something the year preceding, following the adoption of the.
yeah, could be, yeah.
So it feels like it's covered.
Yeah, I think
I
it
don't
is.
remember the point. I mean, like, why the council president brought it up.
I'm not sure if it was because there were mayoral appointees this time around and we wanted it, does anybody have notes?
Well, I think his position was, through the whole process, his position was that it was a city council function and that city council should make the appointments and that the mayor shouldn't have appointments. That was his position. So my only observation is, well, that's what it says now, so we don't have to change anything. It says council shall appoint, and if a future council decided, they'll decide the details on how they want to do it, how many people they want, you know, all those kinds of things. I don't know that we need to get into that.
So
Does the
council does-
ordinance or resolution could say, 5 seats to be appointed by council, 3 seats by mayor, that's. I mean,
Yeah, it
they
could,
still do that.
Okay. Cool. So any more discussion?
Do
Do we have a motion?
we
No.
want to revise this language or do we want to wait and come back to it at some other time?
I think we should come back to it just to double check it, because like the shall was a change.
And the
I-
dates?
And I think it's giving authority over taking action, or it's saying that it has to be in a certain, like, I think we should look at it again, but
Okay,
I think it would be smart just to.
So does that mean we're not
so we're gonna
vote on
just
it, or-
hold, we're gonna park it.
And we don't have any questions currently about this language, we can leave it as is.
Yeah, I think we looked at it previously.
Yeah, I think it's just a fresh eye
We
thing.
wouldn't vote on it.
Well, we already said we liked it. I mean, we're just noting that that he made a comment about it, and my response to his comment is, well, it already says that, so we don't need to do anything.
Okay, so this is what I'm wrapped around is each new review period shall commence on January 1st of the year following the year in which council takes action on the recommendations of the consent commission.
Yeah.
So if they never take action.
Yeah.
It doesn't apply.
But
That,
Like, that's what I'm saying, I think there's some problematic language possibly to dive into.
Or it could say, or every 10 years, whichever is closer or sooner.
Yeah, well, I think the point is you have to say, so this our charter review is in 2024. So if they're supposed to look at it, they must look at it every 10 years and they may look at it every 5 years. When does that period start? So we could say it starts January 1st following the submission of a commission report.
yeah,
Yeah.
But then if a commission never issues a report, you're in the same box.
yes.
Well,
And then the current one's just completely silent on any of that stuff.
there's less likelihood that a commission is gonna submit a report than that the voters will vote for.
Oh.
Well, but we're distinguishing between, what is your measuring point? Is it when council takes action? Is it when something is voted upon by the voters?
And Lee just threw out another is, you could just say commencing on, let's say 2025, every 10 years. Just every 10.
You could.
Just you can have it kick in automatically and not require something to spark it.
That's what the current charter says, the first 10-year period shall end December 31st, 1982. It was instituted in November 72, so they said your 10 years is up in December 82, so they gave a specific date on that.
Okay, so I think saying it's starts January 1, 2025 is fine,
And then I
which is what this says.
should we just get rid of then the commencing?
Yeah. Or you can just yeah.
And then do we wanna get rid of greater intervals than every 5? Like to me, it feels like get rid
No,
of that.
I think we should have that they consider it every 5, and the reason for that is that, to me, the world's changing at such a pace that 10 years is a long time not to touch a charter.
Right.
And good governance would seem to require a little more diligence and,
And they only have to consider it, they don't have to do it.
Yeah, it says shall consider, that's it.
Yeah.
So I'm saying, we're saying that.
So can't we just pass this right now rather than?
We could.
Now we can, now I'm on board with that. So I motion to pass this as we just amended.
I second it. Discussion?
Looks good.
all in favor? Any opposed? Okay. So, the next one is
CA is city administrator.
city administrators should have experience in day-to-day operations of municipal governments. So now the language says, and this is in Article 4 point something. Training and experience, I think in management, it's much more general. So my only question about the proposed language, all right, so it's in 4.4. City administrators shall be appointed on the basis of executive and administrative training and experience. So, and President Coot has suggested that we add experience in the day-to-day operations of municipal governments. My only concern about that is whether it might be too much of a constraint on the pool of potential city administrators, but what do you all think?
Well, I tend to agree with that, because you could have it, we've had this experience in Cleveland where there was somebody who was Race Kilbane was her name. She was a big shot in some administration, maybe the Obama administration in terms of workforce development. And she was originally from Cleveland, but she'd worked in the federal government for many years, and she retired, her husband retired and they came back to Cleveland. She did not have municipal experience. She had federal experience. So you could get federal, people who come from other sectors and other states, that have lots of qualifications, but not necessarily municipal experience.
Can I ask a question? Does the city administrator get approved by council before they're installed in office? I would just say I wouldn't want to, I don't think we have to do anything because the council has full rights to say you don't have the qualifications. I mean, they can make that clear to the mayor well ahead of time, right? I mean, there's no need to have to go through that entire process. If they're really concerned about the qualifications of the person who's been nominated, they should make it clear, and they have all the rights they need right now. So I would just say this is unnecessary myself. That's my
Agreed. A motion to add experience in the day-to-day operations of municipal governments to
requirements. of
section
city administrator.
4.4.
Second.
All right, so the motion was made by Guy,
Jonathan.
by
did it.
Jonathan, and seconded by
Me.
me.
Yep.
Okay.
Me too, but Drew, I spoke more loud,
Yes.
so.
So the motion is to accept Tony's 8, and it's been seconded. Any further discussion? All right, so all those in favor of making Tony's change, say aye. Opposed? Harriet, all opposed, okay. All right. Well, gosh, we're done with that.
With that.
Okay, so we've gotten that done. So Kevin, thank you. And I think we can let Kevin go, because he's got chores to do helping somebody move, so I know he's very anxious to get on with that. We've given you relief for this many hours and now you gotta go join the crew.
Work is so bad that it's worse than helping someone. Oh my God, that's gotta be the worst.
Thank you very much, Kevin.
It's relief from helping somebody move.
Thank you.
It's my pleasure. Thank you all.
Thank
Appreciate
you.
it.
Thank you.
I don't know if you need me on Wednesday, but I think you're meeting Wednesday.
Yeah,
and if you
I'll let you know. I'll let you know one way or the other. Thank you.
Okay, thank you. Bye-bye.
So, we skipped 6A. And just real quick, Lee, did you get any feedback on whether we have a meeting room for the 21st of May?
Nothing final. I've narrowed it down to, because of Steve Berger's availability preferences for the 21st. There's a council meeting on the 20th. He has to
Right,
cover. Plus I think you probably know council members available to attend your meeting. But the room that we had at the last meeting is unavailable on the 21st. So I've asked them about the slightly smaller meeting room on the second floor, but I haven't heard back on that.
Oh yeah, that meeting, that room is pretty big.
yeah, it would be fine.
It is a 100-person.
It would be fine. I'm just concerned about whether it's available because when I was still attending jazzercise classes in person, they used that room some nights. So I'm just worried that it's not gonna be available, and if it's not available, we may need to choose another location.
So we're
we
gonna
really
stick
need
with
to
that,
know-
we're gonna stick with that day.
I think we need to stick with that day, but I think
That'd
we may need to find another location,
And May 21st was the,
Yes.
Tuesday, May 21st.
I've informed Linda already, but I will be out of town that day for a wedding, so
We will
That's-
miss you.
totally fine.
We will miss you.
Can we, before they do the setup of the room, can we help?
Yeah, we'll weigh in.
We gotta do a little bit on that.
Yeah, and it'll be probably a different format this time. I don't think we're gonna need breakout tables, but we'll go on with that. So I wanna suggest, we had decided that we wanted to, at a later point in our discussions, decide on buckets. And I would suggest that we target a time to do that, and that a good time to do that will be at our April 20th meeting, which is a week from today.
yeah, I agree with that. Do it on that Saturday where it's a more intense working session.
Yeah.
Because then that way we can hammer it out and actually have a decision. And then on Wednesday could actually maybe just move along a little more in the edits.
Yeah, we have a lot of stuff to cover that we're not gonna finish today, so we got plenty to do. Okay, so then I think we are now down to, we talked about the non-discrimination. We talked about that other chart, so we're down to Guy's provision on finance and budget.
Finance and budget, and can I beg just like 2-3 minutes for?
You may.
You wanna just come back at 2:20? Take like a 3-minute?
Yeah, just real quick. Biology break, we call this. So we're ready to move on to Guy's suggestions.
I have two.
Which one is it?
I don't think it changed, did it, Guy?
Well,
After you submitted it?
I posted something early on that, and then I revised it after I revised.
So which one's it has the numbers
You
at the
posted
top?
something this
Yeah,
week,
the
right?
underline.
The one that says draft Cleveland Heights City Charter related to budgeting underscore content is not part of the.
Thank you.
Okay?
I don't see.
It's not in this
it's
current
not in the
packet.
stack. It's
It's from last
that's from
meeting.
last week.
Oh.
I have an extra copy.
So I can begin, I guess the first question to address is why bother? Like, why are we doing this at all? So the answer to that question is that this last budget cycle that was used to produce the budget for calendar 2024 was praised by everybody who I had a chance to speak to. And it was praised in part because it was unlike what had been done previously, okay? So it was just like, it was just a lot of support across the board for what happened. The charter itself doesn't really define that, there isn't anything in there to really, it's not in the charter right now. And part of my discussions, I think, I talked to, I reviewed the current charter, I reviewed the model charter, I reviewed the charters of the different three of the cities that we work with, South Euclid, University Heights, Shaker Heights, Lakewood, and ours, I'm sorry, more than that. And took that, I met with Melody Joy Hart, who is the previous president of the council, who was a strong participant with the mayor in the process that was used last for this year. I met with her and then she reviewed my proposal and gave me comments and reflected her comments. I've also met with Tara Schuster, who is the acting finance director of finance. I met with her to review it. I met with her to discuss my draft as well. I interviewed her about the process, then I reviewed my draft with her and reflected her comments. I also referred to the model charter to make sure that I wasn't missing something, so I used that as like a checklist of that. So, any questions on what the process?
Oh, sounds good.
Okay, and then what I did was I put together the content here, and this is not a red line comparison or anything like that because it's just not related to what's in the council right now. So it's really just creative, and it is what reflects the system, the process that was used this last year. And I don't know really. Let's see. Well, I'm sorry. In the text, if you have it, part 2 was the current charter, which is it's 2 paragraphs, and then there's appropriate two sections. I'd rather get into mine if it's okay, and explain. I'll just briefly tell you what I prepared, and why is if that's acceptable. So I used the model charter as a good way to say, okay, how did they organize the information? And I used that as a model, a template. Not as content, but as organization. So the first thing is to make clear that the city's fiscal year is the calendar year. So we got that done. Compliance with laws and regulations. So we make it clear in that section, we're making clear how our process is going to ensure that we are compliant with the laws and regulations that relate to municipal budgets and municipal spending, okay? And in conjunction with that, in order to make those be in compliance with those requirements, I also note in an indented section, council will be provided with information by a certain time, which is what they've had previously and which they've been happy with. But at least it makes it clear that's when they have to get the information. So it's for their consideration. Just for point of information, the budgeting process actually has 2 parts. The first part has to do with tax revenue from the properties, just revenue from properties, no other sources of revenue. And that's a process that has to be aligned with the process at the county for the things that are happening at the county. And that's why there's that activity all occurs and has to be completed by July 20 of any year, because July 20 of the year, that's when the county requires this information. Right. And then after that information has been submitted, they get comments back from this county, et cetera. Then they begin the process of doing a comprehensive review of all revenues from all sources, which includes grants and fees and everything else. All right, and then the expenditures, appropriations for spending in the city, and that's a process which is required to occur by December 31. But I think it has to be by December 31 if you're going to have any kind of budget to use of the new year. All right, but there isn't a reporting entity to which we have to submit that budget. Like there isn't a county budget expenditures committee or anything of that nature. It's just us. Any questions on that part of it, the compliance?
Why did you use the word tax budget instead of budget?
Because
Other
that is your tax, essentially your tax receipts budget from your property taxes. Okay, and that's the term that has been used. Okay, then how do you, then the preparation of the full city budget, which includes all revenues and then all the expenditures, the appropriations, I'm sorry, they call them appropriations. So I've included the specification saying the mayor with the assistance of staff, including the director of finance, shall furnish to council an annual budget document giving the following information. And that's because different are, I think in the current one, it says that the city administrator is responsible for running the budget in one part. In another place, it says that the mayor and the director of finance will prepare the budget. We want to be clear on who's responsible for making the budget. And that would be the mayor, ultimately is responsible for this process, and including, with the assistance of staff, including the director of finance. And I include that specifically only because I don't think any mayor is going to be silly enough not to try to do a budget without their director of finance, but at least just make it clear you got to work with the director of finance, whoever it is. They are responsible. Then what I've done is I've specified what is the contents of the budget that they will provide to council. All right. And so there's an annual revenue budget, which has all the revenues expected plus the last 2 years for comparison purposes. And then it's pointed out very specifically, all the assumptions that have been made will be noted and explanations will be provided for what they're providing in the budget. And the timing of that will be by the 15th day of November, which allows them to complete the work that they need to do in about 30 days and then have 3 readings and then have it passed by December 31st.
November 15th gives them 3 readings?
It doesn't, no. November 15th allows them to complete their work and do the 3 readings, which I think the first reading has to be in the first council meeting in December.
Okay.
Okay, I'm relying on the fact that this is what they said works for them, okay? I apologize, I didn't really go through all
There's
the
only
time.
2 meetings a month, right?
Okay, well then maybe,
I think we'll come back to some of the details. Why don't we let Guy kind of finish the.
yeah, let me finish that. These are the dates that were in the calendar last year. This is what the Tara said that works for them, okay? In any event, that's all the revenues, and the council is then provided the revenue of the budget for the new year, the current year projected out to the end of the year, and the last 2 years. And then there's an appropriations budget, annual appropriation budget, which has the same comparative data, all right? And it includes an estimate of the estimate of the expenses, all right, which again is the 15th of November. We'll validate that being reasonable, okay? And then there are 4 things that are specific, which are not new things, but we're making them clear. This comes from the model charter, saying the model charter indicates these things should be provided to the city. They're already provided in what is called, I'm sorry, I didn't use the term, they call it a budget book, okay, budget book. And that's what the mayor creates or produces and then gives to council, a thing called a budget book. So the budget book will have the estimate of your expenses and your appropriations and your revenues. It will have the total amount of the debt of the city, together with a schedule of amounts due on individual bonds and notes. A statement of projected unencumbered balances in each of the funds at the end of the year, and the actual unencumbered balance at the end of the prior year. A statement of the city's debt rating, and a report of one of the debt rating agencies if it's available. And then E is just any other information required by council. So we always want to give the council freedom to say, I want something else. You have that. So that's on your operating budget. There's also a need to have a capital budget, and the capital budget follows, somewhat similar capital spending by each department and how that spending relates to achieving the department goals, which they're already doing. All right, they're already doing this. This isn't a new burden on them, but that gives council a reason for why they're asking to spend the money. What is the cost and what is the anticipated method of financing? In most cases, anyway, it's just how are you going to finance that spending? And then there's 2 new provisions: the estimated annual cost of operating that capital investment, because that is something that's going to be a burden of subsequent years, and it really should be provided to council. And the fourth thing is more arguable, you can argue about that more, a commentary on how the plan addresses the sustainability of the community and the region of which it is a part. So this makes it clear that we're serious about sustainability, and right now there's part of the executive office is the sustainability director or
Can
something.
you modify that, say financial sustainability?
Ooh, I
No, I think it
Well,
means
no, not at all, it's specifically
This is environmental.
No, it's environmental. It's specific, if financial sustainability is C, you would say that would be point C. No, this is from your ESG, this is from the thrust of what a lot of.
But is this in the context of the capital budget or the overall budget?
It's in the context of capital.
This is in the context of the capital budget.
Okay.
Okay, now it could be, we could have the same thing. It wasn't suggested, or I didn't see it anywhere suggested for the operating budget. But that's an interesting idea. So anyway, I'm sure you won't forget. And then, and for the capital budget, anything else that the council wants, all right? So any questions to this point as to what council will be provided in their budget book? Or any
Well,
comments?
I do have a question on you're specifically talking about environmental sustainability?
Yep.
Yeah.
Then let's put environmental in there. Cause sustainability in the context of budget and finance, it sounds like financial sustainability.
I read it as environmental.
I don't know,
I actually don't know what it means, cause there's so many different types of
Yeah, people
sustainability.
throw the word around all.
well, all right, but is it really just environmental, or does it also have to do with other things beyond what we would describe or understand as environmental?
So in the context of ESG, that stands for, I know the G is
Environment.
governance and the S is social and the E is
Economic.
environmental.
Economic, I think it's environmental, isn't it?
I don't know. I always think of money,
Since you're good at that.
community, money, people, and you speak. You know this. Is it economics?
No, it's not
Environmental.
economic, I don't believe.
I think it's environmental,
Is it social capital?
environmental, social and governance.
environmental, social, and governance.
Yeah, environmental, social, and governance. So you want, I don't know, sustainability, to be honest, sustainability is the term that people are using now for ESG and all in general, but if you wanna make it more specific, we can make that more specific. But let me go on, okay, we can come back to that if you would.
Just sorry, a quick question,
Yeah,
just for my
certainly.
clarification.
No, certainly.
What is the capital budget governing compared to the operating budget?
So capital budget is anything that will require an investment in that's gonna have
Useful
usefulness
life.
for more than 1 year.
Okay.
More than the current year, essentially.
Gotcha.
If it's gonna go more. And I think I took it out here because it just seemed like it was too technical, but basically the capital budget rolls every year. So you're looking at last year's capital budget, bringing forward everything that hasn't been expended and you're approving it again generally, but it's something that it has a life, a
Okay.
separate life that runs.
Gotcha.
Because
So,
things last month.
This is interesting, so my phone says ESG stands for environmental, social and governance. This is often called sustainability. In a business context, sustainability is about the company's business model, i.e. how its products and services contribute to sustainable development. So,
And then in this context, when I read it, I read sustainability of the community. I'm thinking literally of the sustainability of the community, like if we don't do this, Cleveland Heights will disappear. Like,
Well, the
I'm just
quality of
thinking-
life is, it has to do with.
quality
so
of
I'm just, there's a lot, there's a lot of definitions it could be. But did you get your answer, Graham?
Yes.
Do you wanna finish off, Guy?
Oh, alright, so that's the budget book that will be given to council, that's a description, as it's proposed. Alright, then there's two more parts of this proposal. Action on the budget, make it very clear, the council and mayor will collaborate to ensure council and the public have the opportunity to understand and offer comment on the budget by publishing and holding hearings on the budget, period. Now, and publishing means to print in the contemporary means of information sharing. Alright, so there's two things I'm doing there. One is to make clear, and this isn't just for me, it comes from my discussions with Tara and Melody, but I take ownership of what I'm giving you. Alright, is that we wanna make sure the council and mayor, it's clear that they're supposed to collaborate so that the council is clear and the public is clear as to what's happening with the money in the city.
So I searched for what does ESG mean in the context of local government?
Okay,
And I get ESG refers to 3 key factors that affect a government's credit profile, including an exposure to climate risk and other environmental factors, that's the E, long-term social factors, which is the S, and governance issues, which is the G. ESG factors represent areas affecting the long-term sustainability of a community. So that's interesting.
sounds really good to, I don't know that we need to put it in here.
No, but I think it's just,
That's
you know, I
really
think it goes to this point of, do we need to define what we mean by sustainability? Because in this context, they're referring to slightly different than just environmental.
No, absolutely. I agree. That's-
And it's an interesting point because, you know, you could say then in the context of sustainability, if you're trying to make sure that the community is sustainable, you wanna make sure that you're making improvements via the capital budget that you can afford. You know, you're not taking on more facilities and equipment than your budget can support on an ongoing basis. You're overbuilding, essentially. So I had never thought about it, but it's interesting.
Well, because it's new, I think one of the things we should consider is whether or not we wanna include a definition of it here, okay? At this time, the understanding is sustainability means X, Y, Z, perhaps. But I would like to, if I can, finish
Sure.
the present and what I've got. So anyway, it's clear that I'm making a plug for collaboration there. Second action, council shall adopt a budget. Third action, council shall subsequently act to implement the budget. And make it clear there, at or before the first meeting of the year at which the budget is to become effective, council shall adopt the appropriation ordinance. The model, I believe, and also some of the cities that had more comprehensive descriptions here include a portion on such ordinance may provide for an interim appropriation, all right, just in case they can't come to terms with everything, settle absolutely everything until at the December 31. However, the annual appropriation ordinance shall be adopted such that the city complies with relevant laws and regulations. So they have to continue to be compliant. And I think that's 30 days. I think they have 90 days to do that according to some rules. So such appropriation may be amended as necessary from time to time by ordinance, which is just your normal running the city, right? They pass a budget, it becomes the by ordinance, that becomes their plan. And when they want to change it, they have to write another ordinance. Okay, and then I included, I did this, didn't see it. As well, council shall take other actions as necessary to achieve the purposes of the budget. Because appropriations sometimes is not the only thing that you have to do to achieve, to achieve the purposes of your budget. So I include that. I'll just finish one last item and then we can open up for more discussion. Administration and fiduciary oversight is the other category. Council shall provide by ordinance the procedures for administration and fiduciary oversight of the budget. And the point there is that to make clear that council does have a responsibility, it's a fiduciary responsibility, not to step away from this whole process now, but instead provide oversight.
Well, thank you
You're
for a
welcome.
very thorough job. I
Yeah.
appreciate the time you spent on this.
I have one.
Oh, yeah.
So you say to achieve the purposes of the budget, is it explicit anywhere that the budget, they have to state the purposes of the budget, or you just supposed to?
And I'm sorry, I didn't give enough attention to that. In the beginning of the budget book, the first item in the budget book is a budget message from mayor and finance director, either jointly or separately.
Oh,
I'm sorry, I missed that. It's on page 3 of page 3. It's the first thing. They submit the budget book and the budget book includes a budget message from the mayor and the finance director.
It's above annual revenue budget.
Before you get into
Oh,
numbers,
okay.
they have to give you the story as to what they're
Okay.
trying to accomplish.
The budget document, okay. So the message is the intent?
Yeah, that's where they would make their claim as to what they're doing, why they're doing it, how they're doing it.
Okay, thanks for all this. Were you suggesting that this text be incorporated in the,
It would
Yes.
replace what is currently in the
all right,
charter.
so then some looking through the text kind of a thing. There's one in the first section, city County Budget Commission determines if the budget substantiates a need for to levy all. So a need for to levy, I'm not sure if that was a typo or something.
I'm sorry, are you reading my,
Yes, yeah.
so let me
First
see.
page there, budget, like one, I don't know how to define because you've got insets and whatnot, but the second major paragraph, the county budget commission determines
If the budget substantiates a need,
or to
to
levy.
levy, I guess 4 doesn't belong there, need to levy. All or a part of previously authorized taxes.
I haven't read the whole thing. The other thing, I thought everything I heard was the council felt incredibly rushed with getting the budget in November and having to make it kind of thing. I would really recommend that the mayor presents a budget to the council in September or October so that there's much more time, because to have to the end of December to have council meetings and to have a public input session and all of that. So I know this was based on what you heard, but I would really change this, and I'm confused because then in the current sense says shall furnish the council at this time prior to the first Monday in June of each year.
That's the tax budget.
Okay,
That's the tax, property tax revenues. Okay, so that is by the first, and I change it from the first Monday in June to the first council meeting.
okay, that's what I was.
Yeah, and
I agree with Drew's
it's required
comment
by the
because I
state.
believe that somebody made a comment to us, it may have been Council President Kuda, that he would prefer if council had more time with the budget, meaning that the November 15th delivery date was too late. Now I recognize that that may be what the city's typical practice has been, but I know from my experience, which is not all that extensive when it comes to things like budgets, but I certainly worked for many clients that I know were finalizing their budgets like in August or September. They would be after us for information about
I understand.
expected legal bills we were gonna render and stuff like that, and they were clearly looking to have it finished by August or September.
Can I just make one statement? I'm happy to have done the work I've done. I'm quite pleased with what I produced, okay? But I have no sense of ownership in the sense that, we shouldn't change this, we can rewrite the whole thing, certainly dates, I agree with you. I think November 15 is kind of late in the whole, given that 12/31 is when you're supposed to have it all done.
Well, and given the schedule of meetings, because you can't have 3 readings.
Yeah, so,
And also this hits right in the thick of the holidays for most people, between Thanksgiving and Christmas and Hanukkah and all of that, it's just a mess. So I would suggest moving up the date to mid-September, maybe a little bit early because they've just come back from their vacation and they're getting up to speed. So I would suggest mid-October at the latest.
Mid-September might be better because mid-October is just before the election and they're gonna be well, not every year, but some years.
I feel like this is too specific. Like, why wouldn't they just pass an ordinance specifying some of this to allow them to make changes? For instance, you could say the estimate will be provided by council within a reasonable time and then allow them to specify in an ordinance. I'm concerned about being as prescriptive in here, especially what's required in each part of the budget.
I would say, I appreciate that you talked to Melody and the finance director to get their reaction to this and their, their basic approach to whether this seemed reasonable or not. I think the advantage of laying this out is that it feels to me like it's best practices. And that it's helpful sometimes for the finance department to be able to say, gotta do this, we got deadlines coming up, we gotta do it. And it helps the city council do their planning because, they've got planning they have to do as well. And I think it's good to have a little bit of discipline about these things. It's helpful to everybody to have some discipline when it comes to budgeting and finances. Don't ask me personally about my budgeting and financing, but for cities.
I mean, at RTA, I was in the Office of Management and Budget for 5 or 6 years, and I really appreciated not being so codified. It was prepare a budget or there's some of the key points. For instance, the tax budget requirement ties in with the ORC because if you're a taxing authority, the state says you have to do this by blah, blah, blah. And it just seems like if we put it in the charter, it can't change. And I'm just not a fan of taking some of the flexibility away from staff or council. Like in an ordinance, they could say, here's the schedule, here's the deadline. They don't have to go back to the voters for it. Or like with the capital one, listing out maybe some of the key pieces I could see being like, you know, higher level things, but like some of the capital may not be spent, or the request, they may be out of fiscal year if they're like grant money or depending on the funding source or different things. So I would see as being more maybe a little higher level. And I can explain that a little bit better. I'm just letting everyone know what's bouncing around my head.
Yeah, I did notice in this that there were a couple places where you said or by law. So I assume that you added that to give a little wiggle room in case the date
Yeah.
changed?
Yeah, I mean, the council can decide to do otherwise, that's why they.
Well, it's really
Or-
whether the county
sorry,
budget
yeah, the
commission
county-
makes a change.
Yeah, if it's changed, if the law underlying or, you know, applicable law changes, then of course this has to change as well. That's why we want
Yeah.
the dates kept there.
Yeah, so maybe in the next paragraph where you have September 1 of each year, that should also say, you know, or by law or whatever the right terminology is. But I think that the county agency probably wouldn't really have a lot of latitude to change that date very much because you gotta have to know. I mean, they can't decide it's gonna be November. I mean, it's,
Well, that's why, if that's when they're getting their certified numbers for the property taxes, September 1, it's hard to say they should have a full budget to present to council.
by September 15?
Well, I mean, no, I mean, I think, okay, this is just my thinking, all right, they don't, a substantial portion of the budget comes from tax revenues, property tax revenues, all right? And for them to be able to come to council with confidence with a spending plan and a revenue plan, I mean, I do think they have to have that in hand, right? That the county agrees, yes, that's what you're gonna have. They should have that much confidence in it. So it shouldn't, any date that we give them shouldn't be much before September 1 with some time for them to be able to confirm and make any adjustments that they wanna make, et cetera.
I guess the one question I would have about that, and I don't know whether you have any idea what the answer to this is, so I don't mean to put you on the spot, but does the Budget Commission typically dispute whether there's a need to levy all or part of previously authorized taxes?
Well, the budget.
You know what I mean?
Well, the commission is actually the one that's gonna supposedly return to the city saying, you have the taxes that you need or you don't, and so now you have to put through a levy. Right? It's not the city telling the county whether that.
Right, no, that's my point, but I assume that the city presents their, so the city is gonna submit a budget to the county auditor, right, saying this is what we think our tax revenues are gonna be.
Right.
So when this says that the county budget commission determines if the budget substantiates a need to levy all or part of previously authorized taxes, I thought that was referring to whether you need all the money you've already asked taxpayers to give you. Not whether you need to get more
Oh, I see.
by increasing your levy. But I think once you've set your tax rates, you don't change them. You know, if you have a certain millage, if you happen to be getting more than you need in your budget, you don't typically start changing that out of a levy cycle. So I'm a little confused by that.
Yeah,
And again, I'm kind of getting in the weeds of what the
Yeah,
county
no,
budget
I
commission
understand.
does, so.
so can I tell you where the substance of this portion of it came from, what was prepared by Andy, who had been the director of finance? All right, cause Andy and Tara had begun to prepare some materials to about budgeting, which never got completed because Andy had to leave. Andy left. So I don't understand, I personally didn't investigate the county budget commission and their operations. I took it from that.
Well,
See,
I'm
to me, it
kind of,
reads like an ordinance.
yeah, I was gonna say, it seems a little I mean, it doesn't seem to be in, it isn't, it's much more elaborate than the other categories of stuff we're putting in the charter.
Right.
And I'm just wondering, I mean, I'm asking, cause I don't know.
Yeah, no, I
Does it
understand.
need, does the finance arena need to be more spelled out, more, or do we want the finance part of the charter to be more spelled out, more explicit, more, this elaborate?
Please.
Do we want that?
I understand. Please allow me to explain. So two of the cities that we looked at, all right, South Euclid and University Heights basically say prepare a budget. I mean, a little bit more than that, but that's it, okay? But Shaker Heights, Lakewood, and Shaker Heights, Lakewood, and the model all are much more detailed, all right? And in fact, a lot of what I have here is actually pulled from one of the cities. I just made it look good for us, okay? So yes, you can go one of those two ways, okay? But my opinion on that would be that Mayor Wheelow has been in place for 20-some years in South Euclid, and they have a well-oiled machine that runs. And they wouldn't need anything more than that. Whereas in the city of Cleveland Heights, we haven't done that, number one. And also, I was encouraged by the people I spoke to say, we really have gotten someplace good. What would be good is if we can put it in place so that it can't be taken away, it can't be removed.
Does this describe the budget process that occurred this last year?
Yes, except for the new things that I indicated. Okay, this is very much what occurred this last year. And that was essentially Tara and Melody. I wouldn't wanna say I can't quote them, but they showed a great deal of support for ensuring that what we did this last year has a life in the future.
Yeah, it does, I mean, it does look more like an ordinance, quite honestly, than.
Well, it's an ordinance in many cities, not only here, but it's in.
I mean, it's a charter provision.
It's a charter provision. It's a charter provision and it's consistent with the charter provisions in Lakewood and Shaker Heights.
If we look at what the 2019 commission recommended, which Jonathan has got up on the board, it's more detailed than what's in the current charter, but it's less detailed than what he is providing. And it also says down in the last few things, shall submit the budget to the council at such time as will permit council's consideration. It doesn't even give a date, so it has even more flexibility. So I think we need to look at this, the 2019 version of the budget as well, just to see if there's a middle ground. Because this is extremely well researched and detailed, but it may be, as we said, too much for the charter.
I wonder if it would make sense to say, adopt this in the charter and then have a statement that says that the various deadlines may be adjusted by ordinance from time to time. So that it's, city council can decide by ordinance. For instance, if we were to say that the budget should be delivered to council by October 1st, maybe they try that for a while and they decide that doesn't work, and then city council could say, well, we think we should allow a couple more weeks. And they could adjust that by ordinance, but at least we would have the framework for the process set forth and still provide some flexibility so that it could be tinkered with if city council determined it were preferable, or if, I think you already, as I said, have some language in here about what might happen if, I don't know if it's, I assume there's state law that governs some of these things in terms of when the county budget stuff has to happen.
I didn't see any references to state laws, but in a
Okay.
county, yes, for sure.
There's county
level,
requirements.
yeah, county requirements.
Well,
Okay.
So I think, go ahead. I think we do need to change the dates, and since we're getting that the County Budget Commission reports back to the city by September 1st, that gives us a terminus at whatever kind of thing. So I would say that if we give the city number crunchers a month to assimilate that and work it in, then as you said, September 30th or October 1st, a presentation to the council, and then they can by ordinance, and we can put in, council may by ordinance change the dates on budgeting, whatever sort of stuff. But I think we need to give them a date, because this one doesn't at all, and then it'll just be kind of a
I mean, that paragraph in particular doesn't look like the kind of paragraph that belongs in a charter. It's explanatory. It tells us that the Budget Commission determines if the budget's substantially needed, the Budget Commission then certifies. I mean, that's external to Cleveland Heights. And so I guess I just wonder if a paragraph like that should be in our charter.
This is what they call a speaking indictment, right? This is giving us a lot of, this is very educational.
Yeah, it's extremely educational and
And I would certainly,
it's good background.
I would try to incorporate a lot of this into our report, because this is good. Considering the time, I think we shouldn't rush on this, because Guy's done a lot of work and it deserves a lot more attention. We need to look at the 2019 thing as well, so.
I'm wondering if maybe we could, if Guy, you would like to take another look at the extent to which we need that paragraph about what the County Budget Commission does, and instead just reference something about the Budget Commission issuing a certificate to the city, you know, this official certificate of estimated resource that states projected receipts by fund, you know, so that's kind of a marker. And, you know, that gets delivered by September 1st, and then you lay out the expectation that the budget is gonna be available by a given date. But again, have the idea that if the schedule for the delivery of the official certificate of estimated resources should change, or the city council otherwise determines that the delivery date for the budget should change, they can change that by ordinance. That's just a thought.
I have to say I included this here only because it's very hard to imagine how a council person is going to learn about this. All right, it's literally, I mean, it's just, how does a council person become aware of all these things? All right, if it's something, where do they go?
Well, I think
Another
it's
thing
like,
for a training.
Education.
yeah, I mean, I think we need to be we need to really hone in on what should be in the charter and what should be supplementary or complementary. Because, you know, we're gonna have the same issue with ranked choice voting. Everything should not go in the charter. There's other stuff that's important and necessary, but it doesn't really belong in the charter. So I think we have to make that distinction. What and be consistent in all of our categories. What kinds of things go in the charter and what kinds of things should be supplementary, but every bit is necessary information.
I will do that. I
This is
understand.
why orientation and training is absolutely critical. I mean, we had classes just for newly elected just on the budgeting process, so it doesn't have to go in the charter, so that people understood you're gonna have to devote a big chunk of your time to the budget hearings every year kind of thing, so.
Well, another thing is, we're gonna have, I mean, we've gotta, and I hope I'm just not misremembering that we've already touched on this, but I know we're gonna be having a report along with our proposed charters and our proposed buckets, but there may be a need for a third category of additional necessary information. I don't know, and maybe it should all go in the report, maybe the report could be extensively footnoted, or, you know, I don't know, I mean, that would be up to us, I mean, that's up to us.
Appendix 1 budget, you know, appendix 2.
Yeah.
The GFOA, the Government Finance Officers Association, is also a good reference for like public sector budgeting. So just a heads up if anyone gets curious, they actually have some best practices on how you handle the budget book for varying jurisdictions, and they give out like awards if you meet their compliance criteria and that kind of stuff.
What is that name again?
GFOA, it's Government Finance Officers Association.
Okay.
If you want, I could poke around a little and try to get an email out, or if you wanna just look at it, like I'm happy to.
No, if you could do that, I appreciate it.
Yeah, cause
Good for
like
me.
with RTA, we a lot of our process we also put in our budget book. But we're also a state entity, and so different things.
Okay. So I guess then where we're leaving this, Guy, is you're gonna do a little bit more work on this and then bring it back to us?
Yep.
Yes, I'll do it.
Well, thank you very much. I
great,
again, I appreciate all your work
Ton
and
of work.
Yes.
I learned so much just by
Yeah, no,
reading
this
through
is
it.
great.
And then the 20th is what we aim for, right? Not Wednesday.
Oh, right.
Revisit,
Or even, or
April 20th.
I don't know, or do we need to push out even further? Because there's other thing, I just wanna make sure.
I think we should try to have something for the 20th.
For the
if we can.
20th, yes,
Every-
that's fine.
okay.
I would like not to do it by Wednesday.
Yeah.
So the 20th would be great.
Right, okay, thank you.
Yeah, thanks.
So next thing is what?
It's 3:00.
Yeah.
Ranked choice voting. So, well, we're at 3:00.
3:02 to be exact.
Oh, so under, so B is done, we
Yeah.
already did that, okay.
I do have action items. Wanna review those?
So let me just, before we do that, let me just make one comment / suggestion on the ranked choice voting provision. And I did mention this to Harriet, but I wanna mention it to all of you. First of all, to say thank you for putting the draft together. Clearly a lot of work was done on that and I appreciate it. It was good to have that and start looking at it. When I looked at it, I was having, well, I had a couple of questions that you don't have to answer now, and it would be helpful to have them for our next meeting. What is this based on? Which jurisdiction is it based on? And how long has it been in effect? Now, I happened to run into somebody from University Heights the other night at the spelling bee. And he mentioned to me that the same company that manufactures the voting equipment that our county uses also manufactured voting equipment for Portland, and Lee thinks it's Portland, Oregon. So that they figured out how to make the machines work for what Portland, Oregon does, for whatever value that has for you. But my question on this is, I recognize that council has to do certain things by ordinance. Part of our premise for presenting this to council was they wouldn't have to do any heavy lifting because we were gonna do that for them. So I think we have to present them with ordinance language, not just charter language. Otherwise, we're leaving them with a lot of work to slog through on their own, and I'm not through, I'm just not sure how they would handle that. So that's just a suggestion. And then there's something in here, it says if a candidate receives more votes than needed to win a seat, a part of each vote received by that candidate instead is counted for each ballot's next highest ranked remaining candidate. I guess the ordinance is gonna explain how that part idea gets worked out, but I looked at that and the immediate thought in my head was, well, what part? And so I think at minimum, you might need to say a part of it as fully provided by ordinance or something to make it clear that you realize there's a hole there that has to be filled in. But that's it for my preliminary reaction. But again, thank you. A lot of work.
What are the action items, Grant?
Okay, so we've got that Kevin will look at adding contracts and grant awards to the non-discrimination statement. I will try to find that language around moral turpitude, connected to as well the mayoral language for moral turpitude for the next meeting. Lee will be hunting down and replacing the canvassing language. Greg will add the ability to introduce legislation into the training and orientation proposals.
Did you say that Lee's doing that, did you say?
No, Greg is doing the preparing for the training and orientation proposal. Next Saturday, we will be discussing the buckets. And Guy will present again next Saturday.
Buckets and budgets.
Buckets and budgets.
Oh boy, it sounds like a kid's game.
And then
Okay.
I guess we'll get to the language around ranked choice voting on Wednesday.
Wednesday?
Well, we also have to get through salary.
Yeah, we've got other stuff to do too.
Sure.
Is that gonna be Wednesday too?
Well, we're gonna try.
Graham, I'm sorry, I kind of blipped. Did you include the researching of the land acknowledgement?
No. Land
And
acknowledgement.
is it by next Saturday?
I don't,
I mean, Wednesday,
Well,
but
it's,
it
we're
won't-
getting to put up or shut up time. You know, we're gonna have to have something by the 20th.
Okay.
If we're gonna get stuff ready in time to present to the public.
for sure.
We gotta get our documentation finished, we gotta do the compare, we gotta do the buckets, we gotta get a report drafted. And then I would request that Drew and Harriet, who are preparing the ranked choice voting text, think about preparing a write-up that will go into the report on that topic. Since you feel so passionately
Yeah.
about it, I think you're best positioned to draft that.
Okay.
Please. If that's okay with you.
Do you think you need more explanation on the budget process since
Well, we probably do for the report,
before?
if you would like to tackle
Well,
that.
although there's a ton of it, I mean, to me, this is, a lot of this goes in the report and, you know, and we reduce it to, what goes in the charter, whatever doesn't go in the charter goes in the report. This is so thorough.
Well, but that's part of what you're gonna review, we could, certainly
No, I
think about.
think I will,
There probably will be commentary, certainly that's needed in the report to address that as to why we're putting it in there. And I think also it's very relevant to make sure people understand the research you did, the people you talked to, et cetera. Okay, thank you all. Do we have a motion to adjourn? Second?
Call for question?
All in favor? Okay,
Thanks, Greg.
thank you all very much.
Yeah, thanks.